Yes, may I please. My lord, item number 10, my lord. This was earlier a part heard matter, my lord. It was heard on 24th April, my lord, and thereafter it was fixed on 8th of May. Thereafter, on 8th of May, my lord, this matter came before another coordinate bench, and that bench has indicated that this is a part heard matter.
How
So,
can the other ones can say?
No, it didn't say.
Huh?
Chief Justice of Yakut,
actually,
whether the court can constitute another bench or it may be placed
We'll
before
see
this
that.
bench.
Okay, we'll see that.
yes.
Yes.
May I please, your lordship, I beg to mention item number 7, my lord.
7.
Yes, my lord. Can this matter taken after 2 weeks, my lord?
Yes, MS Mia.
Lordship.
On the prayer of Mr. D. Bora, Learned Counsel for the appellants. Is deferred for a period of 2 weeks. MS Mia, give me a right to senior an additional public prosecutor, the paying for the respondent state of Assam has no obligation to proceed. Is there any objection?
Yes, ma'am.
2 weeks.
May I please, your lordship, I beg to mention item number 8 of today's daily list, lordship.
Hmm.
Due to some personal difficulties, lordship. So lordship, can it be come after a week, lordship?
10 to
30
The
of
prayer of Mr. N. Polita,
we will not mention.
Learned Counsel appearing for Mr. A. Polita and communication for the appellant. Release the appeal after the week. MSB present.
of life.
State.
May I please. Well, I'm mentioning for listing of a matter for orders, my lord. It was
For
pending.
orders for what?
My lord, the paper was directed to be by lord prepared. It's pending from August 23. my lord.
File of
May it please your lordship. I'm convicted in this case under section 376(2)(f) and 6 of POSCO Act, your lordship. The
May I please your lordship, these appeals are against rejection of bail application before the Learned Special Court. All these cases arise out of the same NIA matter, lordship. The records have been received, although it reflects in one case. It will be the same record. Therefore, if your lordship will, subject to what my friend says, if it can be taken up on Tuesday for hearing.
For hearing, well,
next Tuesday.
Tuesday for
It is already recorded as hearing
well,
in the order.
It's coming out. So,
According to you, records are sufficient.
yes,
It's
yes,
the same record,
same record.
same record for all.
Okay. Heard Mr. N. Borman, Learned Counsel for the appellates. MS S.H. Bora, Learned Additional Public Prosecutor for the respondent number 1 and 3, and Mr. R.K. Dev Chudwi, Learned Deputy Solicitor General of India for the respondent number 2, and I. Which, Mr. D. Bharadwaj, Learned Counsel for the respondent number 2 and I. Full stop. Learned Counsel for the parties have submitted that all the 3 appeals have arisen out of same and NI case number, special NI case number 2/2023.
Lordship.
Full stop. Since case records from the Learned Trial Court is received in respect of one appeal, it is submitted by the Learned Counsel for the parties. The said case records would be sufficient for consideration of all the 3 appeals. List the appeals for hearing
Tuesday, my lord.
Huh?
If possible, my lord, Tuesday.
28, 28, 28
My lord. Deeply obliged.
as sought for by the total for the parties.
Number five for hearing.
My lord, it was for remission. Perhaps certain report has come. my lord.
Lordship, report has come. There's an adverse remark from the convicting court, Lordship, regarding remission of process, Lordship.
Much space খন দিলেই হ'ল, গোটেইবোৰ দিব নালাগে।
Hello, Indeed does. Oh, see, I believe it's not. Yes, please.
But this report has to do with something.
Lordship, Lordship, yes. My learned friend has submitted in the earlier occasion, Lordship.
We have to dispose of it separately.
On the,
Either way.
yes, Lordship, on the matter, on the hearing,
Yes.
on the merit, Lordship.
So, it would not be, yes, because of the advice report given by.
From the
station.
Convicting court, Lordship.
We can select that report.
Let the matter be fixed for hearing, Lordship.
Yes. Otherwise, it is completed 19 minutes.
Lordship.
as per his office memorandum, and plus the convicting court has passed an adverse opinion. Now, the next step, I think, is that for the Inspector General to submit the proposal of remission to the government
Yes.
along with his recommendation.
Yes,
And it has said that conduct reports from the Deputy Commissioner and Superintendent of Police.
still
Are
awaiting,
still awaiting.
still awaiting.
So that is irrespective of the appeal otherwise. This procedure is an independent procedure. That for an offense of murder, minimum 14 years is required. Thereafter, a proposal for remission can be might be considered by the government. That is an independent party. It has nothing to do with the appeal. So what do you propose? Now, this is the situation.
Yes.
Otherwise, considering the fact that he is behind the bar for 19 years,
19 years.
it will not be proper to delay the consideration of the appeal.
And Lordship will take up some other day, awaiting the Malord report. I have not prepared Malord the case.
Okay,
Yes,
but I think we cannot wait for the,
correct, Malord. But I thought, Malord, that in fact,
Right.
now since the adverse report has come, I thought, Malord, any order or judgment from this honorable court upholding the conviction might have some bearing on, Malord, the consideration. Now, since an adverse report has come, Malord, now that, Malord, ground
There
has
is no
gone.
other option.
So I thought to await, Malord, until the honorable courts decide, let them take a, Malord, call. Now, adverse report has already come. So therefore, Malord, that point has gone. I will argue, Malord. Submit.
will not observe anything as this.
Yes, no,
because
not necessary, Malord.
Inspector General of Police still has the discretion to submit the proposal to the
Yes.
state government.
But since
Along with the convicting court's remarks, Superintendent of Police and District
District
Commissioner.
Commission.
Then government will consider.
But CRPC 432(2) says, my lord, that the convicting court, my lord, will state his opinion with reasons, my lord. But whether there are reasons or not, it's not, I don't know.
That you have to find out, then
Yes.
prefer a separate proceeding. for that.
No, what I'm trying to say, my lord, since it has been rejected, now perhaps the government will also, my lord.
That,
in the
that
same
is
line.
not the mandate,
Yes, that is not the mandate.
adverse finding. That is not the mandate of the government policy.
No, no.
That superintendent of jail will obtain remarks from district judge convicting court, superintendent of police and district commission. And forward the proposal
To the
along with
government.
his recommendation to the state government. And thereafter, state government will take a call on the basis of 433, 433A, 432 CRPC.
Correct.
Now that is still awaited.
Awaited.
District Commissioner and Superintendent of Police report.
Yes,
So he said that this cannot be forwarded at this point
Yes.
of time,
yes,
as the reports are awaited. And that is his opinion, but so far as convicting court is concerned, it has returned with an adverse finding.
adverse remark.
That is the position. So that is an independent
Right.
proceeding. I think, considering the fact that 19 years.
Yes, yes. Lordship will take up, my lord.
How much time you would require for preparing?
At least 7-10 days time, my lord.
After 2 weeks, then?
My lord.
SK Talukdar, learned amicus curiae for the accused appellant. And MS SH Bora, learned additional public prosecutor for the respondent state of Assam. MS Bora, learned additional public prosecutor. In deference to have submitted a report from the submitted a communication being number so and so dated 6/5/2024 from the Superintendent District Jail Depot, in deference to the previous orders passed post from the state communication, it transpires that the Inspector General of Prisons, Assam, has not yet submitted a proposal for remission to the state government, which is recommendations, as the reports from the jurisdictional district commissioner and the superintendent of police are awaited. Be that as it may, as the instant appeal is a jail appeal, the appeal requires final consideration. At this stage, Mr. Talukdar, amicus curiae, the Supreme Court applicant has submitted that as he was awaiting the outcome of the remission proceedings, he could not prepare for final consideration of the final hearing of the appeal. So he has now sought listing of the appeal for hearing after 2 weeks.
Organized.
MS Moral, additional public secretary, has agreed to the safe prayer of the amicus curiae. List this appeal accordingly after 2 weeks.
Organized. Mr. Hajage informed me yesterday that he's aware of the matter has come up today. Here, co-accused has been released on, acquitted. He was acquitted.
Then what will be the effect?
I have still submissions to make, my lord. Lordship, merely because the co-accused has been acquitted, there are materials against instant appellant.
How this appeal is to be considered?
Yes, your
That
lordship.
day I was reading, but now I could not lay my hands.
My lord.
That day I was reading, perhaps it was submitted, right? 34.
Yes,
Could not lay my hands.
there are judgments, I have
Second-
found out, my lord.
Exactly, then I remembered Mr. Hazarika's submission.
Yes. But here she is the wife, other one who has been acquitted was not. Allegation is that this lady had an affair with,
That there it was discussed that to find out the role of this kind of accused, where the co-accused has been already acquitted. And state has not prepared any
yes,
against
Lordship.
that acquittal.
my lord.
So what will be the nature of consideration?
Lordship, according to my submission is that, my lord, yes, Lordship is still, Lordship
Right.
consider the evidence and record and independently assess the evidence which is against her and pass appropriate order as per law under 302 simpliciter, my lord.
302 simpliciter.
My lord.
No, that is not the
Lord,
law.
I have got 3 judgment and we need to just.
I think also I have also given some judgment last occasion.
Even some judgment, what is the judgment? Tell me, then I can read.
No, I guess
Citation.
additional regarding that co-accused.
No, regarding cook is okay, but
That's only co-accused.
which judgment?
Yes, I'm.
Given citation will not do. Particular point out,
My lord,
Lordship,
Which-
Mr. Hazarika, you have given 3-4 judgments.
yes, my lord.
Which one?
All are on the same point, but almost.
All are,
that
but-
because that on Poiku should also be.
Point out,
Yes, yes, that is one is, I'm giving my. Can you bear, sorry for. the delay on this. Even if you-
আছে ন? সেইকাৰণে গ্ৰীচটো দিয়া নাই, ছাৰে চাব পাৰিব ক'লে। টেপটো আছে তো
No, এখন বিচাৰি এখন পালিছো।
আৰু এটা ব্ৰাজিল খান বুলি কৈছে মানুহ
বাকী কোনো কৰা নাই নেকি?
নাই আপোনাৰতো নটিছ
Fight to have a.
মইতো বহি গ'ল next আছে।
2008, 15.
অৱস্থা নাই দৰ্শন চিনে আছে বহুত লৈছে সময়টো কৰি
anyway, which one?
One I've got, my lord,
Citation.
sorry for delay. That is one 2006 10 SCC,
2006,
10 SCC,
10 is, it is not here,
542, I think. that-
not here. You have not provided. Do you have copy? We are not.
I'm sorry for the,
2006.
I missed it, my lord, I think. That is.
You should have provided.
No, I thought I'd have provided in last time occasion when.
No, you have seen 2001, 2 SCC, we have, then 2004, 1 SCC, and 1991, 1 SCC. I don't think there is more.
There's one 2008, I think 15 FCC is there.
It's okay. One copy. One copy is available. It has again. Okay, 2006, 10.
2006 10 SCC.
542
Okay, let us see.
That is. The last paragraph of that, lots of got it, my lord. Or in the para 3, it is said,
Para
3. This very short judgment, don't wait.
This is Trimukh Maruti Kirka.
No, 2006 10 SCC.
Trimukh Maruti Kirka.
But
it will go against him.
No, not Tribuk. I have not. This is Aruka Thomas.
No, that is.
Aruka Thomas. Trimut is the, that is in regard when there is, it is something with, when no one.
It is not available. Somebody has given Trimukh Maruti Kirkan.
Maybe I have given last time.
She has given them.
We have not given anything.
But the argument why nasila?
Argument one is no day, double is not. Anyway, there are judgments, I may be aware of it also. I'm sorry for that. Actually, I should have provided earlier. Why not? Actually, I thought I provided in the last occasion. This is the matter has been called up. It's early. There is another one, 2003, 4 SCC. Suresh Chaudhary is, what you, I think, is Jamal. Suresh Chaudhary.
No.
Then I can provide this one with.
We have Trimukh Maruti Kirkan.
That was provided by
Grace.
probably.
Would have figured, no? I did. It is welcome, then,
Conviction of.
2003, Suresh Chaudhary.
Suresh Chaudhary, my lord.
Which part? One copy we have.
Yeah, not a copy, I have got it, my lord.
Which part?
In the head note G, it is there, my lord. I will. This para 14 is there, my lord. That part it is. In that para it is there.
And that is a defined principle, non-appealing.
Non-appealing, but he is a co-accused, my lord. Even though non-appealing, my lord. But he also stands, this appellant also stands the same thing here also, my lord. Although non-appealing, but he also should get benefit. That is the, our High Court also says that once I got gone through in my, but.
No, I read exactly a similar judgment. Hey, Harry. Hey, go to. That is what I was telling. MS Bhuiyan, that
No.
I exactly.
This matter only came earlier bench, my lord, when your lordship said. Lordship, co-accused been released on bail.
know how this is to
We
be.
dealt with.
dealt
May, lordship, may I refer one judgment?
Okay,
And 1955 to SC, AI 1956 SC 116.
you refer without.
Lordship, I thought
copy
lordship is
to us.
having, no, my lord, lordship is having that tab.
Huh?
I have not given the judgment. It would be available online, my lord. William Stanley, Slaney versus State of MP.
Stanley.
Five judges bench.
Can I have it? Or have one? We could have the written word to execute.
Lordship, may I give my copy? Hurry.
In Sona, it's a Suresh Chaudhary's case, lordship, it is dealt with like that, even the non-appealing. But they are on the same footing, but the present appellant, only here is appeal, but fact is they are been charged with same offences, no?
I distinction effects, makes a whole lot of difference.
So when non-appealing, my lord can get the benefit, here an appellant has a stands on a higher footing, if the lordship agrees with it. But still, here, he has come, here, my lord, then main protagonist in this case, my lord, he has not been identified, because the appellant of the other main convict, the accused person who has been charged with the offense of committing the murder, he has been acquitted, my lord. So, and she, this parent appellant only because she came in because of the conspiracy theory, my lord, with 120, my lord. Because of conspiracy, but now with whom she has conspired, man? When the
34 is not conspiracy.
Oh.
Whatever one
But it
twenty
appears
is
my
there.
lord that she has
Yeah.
from the
120
evidences that is come.
34, 302 and
She-
34
yes.
in the instant case. 120 আছে নি দাদা?
120
Nine-
but evidences reveal that because she has conspired with the person who has committed the murder. Now that person has been accused in my lord. It should have been here, my lord. It is 120 is not here. 34 is there, my lord.
Yes.
But the evidences reveal that she has not committed the
Lordship,
murder.
it may.
There is no allegation that she has committed, actually no.
কইলো।
There is no allegation that she has committed the murder anywhere in the evidence, my lord. Only that she has helped the other person who has committed, but that is the actually evidence that reveals, my lord. But that person has been already acquitted, and now who is the person that is not identified?
Right.
So in that
Para
circumstances,
21.
my lord, I think lordship, the benefit of it
Para 21.
should also go to the present appellant, my lord. The main protagonist in this case is not present, so identified, my lord.
21 to put together.
But Suresh Chaudhary's case, lordship, I think, there are other, not only other, there's other one also,
No, Marco
my lord. Let us para 14 lordship may,
I have seen.
yeah, that only because he's not appealed, but the charge was same, my lord. And then the other one, Arab Khan, that I have seen.
See, all right, but because when the embark. To decide this activity,
Then
the observations in by the coordinates while meeting the other way. We nothing to be done.
Yes, Lordship.
Yes.
So,
Oh, it's okay. Yeah,
my
yeah.
lord, I'm sorry.
So it has to be. It should not be, there should not be any.
Yes.
The judgment of the other guys. How to.
Yes.
That is the concern of this court.
Yes.
Mr. Hazarika, it is not a concern. So that while embarking on to decide that.
Yes, my lord.
So that nothing
Yes.
yes, that is,
is observed against the judgment. That is the concern.
that's right, my lord.
There are judgments on it.
This court also
That is
has,
why.
that is true, this court also has independent view.
Whatever exists.
This court also has independent view as well, it's true, my lord, yes.
How to deal with it, that is why I call acceptance. Right, this actually
No, I have also
not
come to my lord. Yes, my yes, good.
to decide it, it is not from my figures, but we should keep at the same time. How this, the judgment of the court is measured. Is that also? So that it should not go against the established law. Is what the concern.
That's true, my lord.
Oh, no, judgment.
I have seen
Acquitted, no?
that court is measured.
Acquitted was. মাঝতে কেমন আসলে last time হলে। Yes, we like to করে না। নহয় না? একটু পারবি না এবার পুরো ইউজ আপনার মতো দিলে
Corona doesn't see.
তুমি মোটামুটি ও চিন্তা ভাবনা
Oh, hate it.
Oh.
Oh, I go hate it.
Oh.
But there is.
তুমি দিছিলে কবে এটা
Actually,
61 is the pressure is the.
but the other,
Lordship, one of the
the other one also I'm aboarding, that 2000.
This is a very.
No.
But that became none.
Asking, this is horse like.
This one also on, it is a co-equals on co-equals malot, getting the benefit malot.
Again, non appealing.
Malot.
No, here, para 21, I have given one judgment.
It's non appealing. This is not appealing,
Lordship.
non appealing.
That one, my lord. Another one.
Thomas.
No,
That-
no. She has.
Full result.
Para 21, here no state has been filed.
Prathi is available.
Lordship, in that case, Lordship, if your Lordship, your father proceeds with the matter, can be Lordship, like, give me, let me remain pardon for today. I will provide that judgment as your Lordship would desire. Desires.
Exactly.
No, even in our High Court also have the same judgment.
Play my hands today.
Nice.
Sitting
that-
here, I cannot play my hands.
That is true.
Yeah.
Nice.
I have. Yeah, played the judgment. The judgment. It's 161.
Yes, my lord. Here, Lordship, I'll try to differentiate. Court did not rely on.
That contradictions, actually, that was
So,
due to contradictions are there, which is
so me, how contradiction was brought?
that is the main.
PW consider. PW4,
All of us read the judgment
my lord.
by their own. You
Lordship.
have to read it louder tone.
Evidence of PW4. my
No,
lord.
no.
That judgment of judgment,
Oh,
ordinance, from which parameter? Who's that?
You can hardly 10 paragraphs.
Yes, the reasons are provided.
sir, do you want a copy?
Heard from him, the heard Mr. So and so, Senior Counsel for Appellant and
Who is that?
for Appellant and Mrs. S. Zahan, Learned Counsel, APP for the state. Para 2 and Azhar, para 2, my lord, and Azhar dated 18/4/2011 was lodged by Muhammad Amiruddin, son of late Kitab Ali, before in charge Dumduma PS, stating that at about 1:30 AM on 18/4/2011, Monday, some unknown miscreants had killed his nephew, nephew Babar Ali, while he was sleeping on his bed by dealing cut blows on his head with sharp weapons. Upon a hue and cry being raised by the children of the deceased, he immediately went to the place of occurrence and saw the dead body of Babar Ali lying on the bed. The informant, the para 3, the informant, while deposing SPW1, had stated that his house is situated near the house of Babar Ali. And on the relevant night, when the occurrence took place at about 1:1:30 AM, he went to the house of the deceased. Upon hearing a hue and cry, he further deposed that the daughter of the deceased Babar Ali, namely Irfana and son Rashidul, had told him that their father was murdered, but they did not say who was the murderer.
Wait. 37.
PW2 and PW2, PW5, PW6, PW8.
হয়, এই জন্য তো জানে বুলি কোৱা হয়। অ,
না, ওলা কৰিছে। মোৰ risky zone। মোৰ কৰিব দিছে।
No, sir.
আছে?
Okay, let us read that.
Yes, evidence.
Have you read
Yes,
the other judgment?
yes, my lord.
Come to paragraph
Yes, my
eight.
lord. Right.
Come to paragraph eight.
Yes, ma'am.
You read the deposition of the investigating officer. Paragraph six.
PW4 Horen Gogoi.
Something is quoted.
14.
Quote, unquote.
Yes, my lord.
Those are 161.
Yes.
And paragraph seven.
Para 7.
Para 6. Okay.
And the PW4 stated before him that she saw one person wearing a lungi was running away, but she could not recognize him. Yes.
Okay. This can be quoted.
No, she should be marked, should be shown to the,
Okay. Be quoted. He simply said so and so did not state in her previous thing. This is for the purpose of contrary.
yes,
There is a process.
my lord.
161 statement cannot be quoted in a judgment. Unless it is,
Motion.
it follows the procedure of 161, 162,
Two.
145,
Five.
154.
Yes,
Right,
yes.
then come to paragraph eight. Last part, last three lines, the position of the investigating officer, PW4. Makes it
Deposition.
explicit that PW4 had not stated before him that she saw accused Abdul Muttalib leaving the place of occurrence. Now, next line. The statement of PW4 under section 161 CRPC is also inconsistent with her deposition before the court.
Motion.
How can this be recorded? Okay, let us read that.
Yes.
Have you understood?
Yes, my lord. My lord. I could not recollect the latest judgment your lordship referred earlier,
No, no, no.
but it Tasida Singh,
Please,
yes, yes, yes,
Here has relied upon 161 statement, which has not been brought on record.
my lord. Cannot be done.
You can,
Yes, ma'am.
you appear.
No, no, I am.
Regarding that, lordship got
160
contradiction.
statement to-
Recorded.
নহয় নহয় ৰেকৰ্ডত আছে যেনেকে কোনটো আছে
Okay. FIR.
Yes.
FIR.
Yes, ma'am, page 4, it is in the paper book in there.
Facebook.
May I read, madam? Humble submission is that at about 1:30 AM today, that is on 18/4/2011, Monday, some unidentified miscreant killed my nephew, Muhammad Babar Ali, aged 35, by stabbing his head with a sharp weapon while sleeping on the bed. Later, I rushed into the house of my nephew after hearing the hue and cry of his children and saw the dead body of Babar Ali was lying on the bed. So that is the minor connection. That is, this is not name also minor here. Neither the other is also nameless. subsequently say came, initially she was a witness also. Okay. Evidence stuff.
That's the Charles.
Just page 6.
It's page 6. Firstly, that you have on or about.
Yes.
Yes, firstly, that you on or about the.
We have it, but something is missing or what? In furtherance of communication,
Communication, that should have been
missing, that is missing.
actually 120 B.
Okay, not one.
To have a, not to have a.
Of enemies.
Oh, common misses now. Common intention.
Evidence,
Evidence.
page 9 is PW1. I know the accused, they are Mutalib and Parvina Begum. The deceased Babar Ali is my nephew. So regarding death of Babar Ali, I lodged an Azhar is the informant before the PS police station. My house is situated near the house of Babar Ali, intervened by road. On the relevant night at about 1:30 a.m. On hearing hue and cry from the house of Babar Ali, I went there and saw the house of Babar Ali was opened. I entered inside his room. Then the daughter of Babar Ali, Irfana, and son Rasidul told me that their father was murdered, but did not say who was murdered. That their father was murdered, but did not say who was the murderer. It should have been murder reason. Then I went near the deceased Babar Ali and saw his head injury, as there was lamp chakki was burning. The injury was caused by sharp weapon. Parvina Begum, the wife of Babar Ali, was sitting near the dead body. Then I raised hue and cried. Neighboring people gathered. On the following morning, I lost the Azhar. I do not know how Babar Ali died. The Azhar was written in the police station. Exhibit 1 is the Azhar and my signature. Cross number. I do not know who killed Babar Ali. Before lodging the Azhar, many people gathered in the house of Babar Ali, but none could say how Babar Ali died. I wrote in the Azhar that some unknown miscreants killed Babar Ali at night. I am unable to recollect whether I said before police that there was a chakki or lamp burning in the room. So that is the evidence of the PW1, my lord. He is the informant and uncle also of the deceased. So he has not made any whisper against the man, present appellant man. In the evidence also. In informant, he also the informant also in FIR also he has said nothing against her. And PW2, my lord. May I proceed, my lord? PW2. I know this is PW2 Subed Ali. My name is Subed Ali. I know the accused person standing in the dock. They are Abdul Matlib and Parvina Begum. The accused Abdul Matlib is my nephew and Parvina Begum is the wife of Babar Ali. The complainant Aminuddin is my brother. The deceased Babar Ali is my nephew. About 4 years back, Babar Ali died. At the relevant time, I was in my house. My house is situated at a distance of 100 meters from the house of Babar Ali. On the relevant night, at about 1:30 a.m., the informant Aminuddin came to my house by making hue and cry and told me that Babar had been killed. Then I rushed to the place of occurrence along with the informant. I saw Babar was lying dead on his bed in a pool of blood. I saw bleeding from his head. Seeing the position of dead body, I suspect that Babar Ali was caught by someone and killed by others. in the house of Babar Ali, his wife and his children were present. Also, the village people came there. I do not know how Babar Ali died. Also, I was not told by anybody how he died. Cross, the difference, I do not know how the incident took place, that much. only. So here also nothing is disclosed from as regards the role of the appellant. Then please study my lord, that PW3 my lord. My name is Habibur Rahman. I know the accused person standing in the dock. They are Abdul Matlib and Parvina Begum. The accused Abdul Matlib is my cousin and Parvina Begum is the wife of Babar Ali. I know the complainant Amiruddin. The occurrence took place on 18/4/2011 at about 1:30/2 AM. At that time, I was in my house, which is situated at a distance of 100 meters from the house of Babar Ali. On hearing commotion of the children of Babar, I came to his house and saw the dead body of Babar was lying on his bed. On seeing the dead body, I could emerge that he had been killed by someone with sharp weapon. There was bleeding from the head of Babar Ali. I saw the wife of Babar Ali, namely Parmina Begum, was sitting near the dead body of Babar and she was weeping. I asked Parvina as to how Babar died, but she did not reply. I asked the 10-year-old daughter of Babar Ali, namely Irfana Begum, regarding the incident. Then she told me that she saw some person going out from their house. Irfana is the middle daughter of my brother Babar Ali, but she could not name the assailant and also could not recognize anybody. I had a suspect in my mind that before the incident, Babar Ali found the accused Matlib and Parvina were roaming, and regarding this, there was a quarrel took place, suspicion only, place between them, Babar Ali and his wife Parvina Begum, and I have suspected that out of this quarrel and relation, my cousin brother was killed under objection by defense. I strongly suspect that accused person Matlib and Parvina killed. So he only suspected them because there is some relation between them. He only submitted in this evidence in this regard. In cross-examination by defense, police asked me about the incident. I do not know how the incident took place. It is not a fact that I did not state before the police that before the incident, the accused Matlib and Parvina were found roaming by Babar Ali, and out of this there was a quarrel took place between Babar and Parvina, and I have suspected that due to that quarrel and relation, the accused persons killed my brother Babar Ali. It is also not a fact that I did not state before police that I strongly suspect that accused person killed my brother Babar Ali. I did not see the incident. I do not have any direct knowledge who killed Babar Ali. So that much is my evidence, my lord. But his evidence regarding the relation is not stated by the other two evidence, 1 and 2 also, my lord. Nothing is there related to illicit relationship or what. PW4. Irfana and the daughter, my lord, of the victim as well as the appellant. My lord. One of the accused is my mother and one is my jetha, that is my father's elder brother. Complainant Amiruddin is my grandfather. Deceased Babar Ali is my father. The incident took place about 4 years ago. At that time, I was studying in class 6. The incident took place in the night. I was sleeping along with my father at the time of incident. At the time, I awoke up from sleep after hearing my mother's cry and saw that sitting next to my mother was crying loudly. I saw Matlib going out from our room and saw about 3 of the 4 persons running away, but I did not recognize them. Today, Matlib is standing on the court. When I asked my mother, she said that Matlib killed my father and ran away. I saw injury on my father's head from where blood was oozing. Then I called my elder brother, Rashidul, screaming. When Rashidul arrived, I told him that Matlib fled away after killing my father. Hearing our hue and cry, neighboring people came, and next day my father was taken away from our house in dead state. The police came. Cross. I was studying in class 6 at the time of incident. My sister, my parents, and I sleep on the same bed. We all slept in the same bed. So they were sleeping on the same bed at the time. So that, but my consideration on the
So PW?
Four.
PW4, a daughter of my lord.
her statement is regarding sleeping is not consistent.
Yes.
She can cross.
Yes, my lord. We slept
I
on
was studying in class 6 at the
Yeah.
time of incident.
Right.
My sister,
my sister, my parents, and
parents.
I sleep,
my
parents,
sister,
yes,
my parents, and I sleep on the same bed.
on the same bed.
We all slept in the same bed
We all same
on the
bed.
date of the incident.
Yes.
Okay, this is once. Then we slept at 8 o'clock. That's next part.
Yeah.
Upon
Upon entering our house.
the room where my father and I sleep comes first.
Yes, my lord.
At one point, she said, my parents, my sister, and I sleep on the same bed. Then next part. She
Yes.
said,
Father and
my father and I sleep. Again say, my elder brother room comes first. We sleep with the lights on. On the other hand,
the police. I
in
guess.
chief, I was sleeping with my father at the time of incident.
With my father, yes, that's two different.
Yet not consistent.
Not considered regarding the sleeping, that in cross reference, he's sleeping with parents. Then, that is, it is not a fact that I did not tell the police that the light was on. It is not a fact that I did not tell the police in my statement that I saw Matlib going away from our house. It is not a fact that I did not tell the police in my statement that I did not inform my brother Rashidul about Matlib going out. It is not a fact that I did not tell police in my statement and that I saw Matlib and about 3/4 persons running away from our house. It is not a fact that I did not tell police in my statement that I saw injury on my father's head from where blood was oozing. It is not a fact that I did not tell the police that when I asked my mother, she said that Matlib had killed my father and fled away. It is not a fact that I did not tell the police that when I called Rashidul, he came and I told him that Matlib has fled away after killing our father. I told the police that I didn't see who killed my father in the night because I was young at that time and I didn't understand properly. It is not a fact that I did not see the incident and I do not know who had killed my father. And so I told the truth to the police and I did not witness the incident. So it's her evidence only regarding as against the appellant, co-accused Matlib, not the present appellant. That too, that is contradicted and proved by the IO also, my lord, a contradiction.
Nothing is contrary.
No, in 161 statement, as per, he has not stated all this thing that is. All this
Okay.
thing.
Pardon.
PW5. I know the accused person standing in the dock. They are Abdul Matlib and Barbina Begum. I know the informant Amiruddin. I also know the deceased Babar Ali, who is my nephew. The occurrence took place on 18/4/2011. At the relevant time of the occurrence, I was in my house. My house is situated at a distance of 60/70 nulls from the house of the deceased Babar Ali. On the 11th night at about 3/3:30 a.m., after hearing hue and cry, I awoke from sleep and went to the house of Babar Ali and found him lying dead on his bed. His head was found in two parts. Brain particles were found lying scattered in and around his bed. I found Parvina, the wife of Babar Ali, was sitting near the dead body of the Babar Ali. At that time, many people gathered at the place of occurrence. I know that there was a land dispute between accused Matlib and this is Babar Ali. So land dispute story is also there, my lord. We guess that the accused persons, Parvina, had killed Babar with the help of Matlib. While police came, I was present there. In my presence, police seized some clothes from the dead body of the deceased, but I have forgotten that where those clothes due to passage of time. Exhibit 2 is the said sigilist and exhibit 2(1) is my signature. Then the evidence of in the cross to the court. Why do you guess that the accused Parvina Begum killed her husband Babar Ali with the help of Matlib? Answer: as we noticed that accused Matlib used to roam in and around along with Parvina, wife of the deceased, and over that issue Babar Ali had dispute with his wife. The accused Parvina used to live in the house of the accused Matlib frequently at the relevant time. There is not quoted in the in bracket it is given me. It crossed my by defense. I did not see the incident at the relevant time, and still our Gambura is Yakub Ali. I found 4 or 5 people present at the place of occurrence. I know their names. They are Razab Ali, Zubaid Ali, Abdul Kalam, Amiruddin, and Hussein. I did not accompany Amiruddin at the time of lodging the Azhar. The first Azhar was lodged by Amiruddin, and therefore another Azhar was lodged by Habibur. I accompanied Habibur and I saw him lodging Azhar. I saw accused persons roaming together in and around a village. I never followed him while they used to go outside. I do not know whether the accused person used to go to doctor or to the market or to some other place. No male village meeting took place with regard to frequent roaming of the accused persons together. I do not know how many persons and daughters are left by the deceased Babar Ali. It is not a fact that I have stated falsely that the accused persons used to roam together. It is not a fact that I have land dispute with Matlib, and as such I have deposed today implicating him falsely in the case. It is not a fact that I did not state before police that the accused Parvina used to reside in the house of Matlib frequently during the lifetime of Babar Ali. So this evidence is not corroborated by others, mother. The PW6. The Gaubura, my lord, is I know the accused person standing on the dock. They are Abdul Matlib and Parvina Begum. They are from my village. I know the informant Amiruddin. I also know the deceased Babar Ali. The occurrence took place on 18/4/2011. At the relevant time of occurrence, I was in my house. In the morning at 7 a.m., I heard that somebody had killed Babar Ali. Then I went to the house of Babar Ali and found the dead body of Babar Ali lying on the bedside inside his house. I saw cut mark at the neck of Babar Ali. Here is a neck, madam, and blood. There were blood marks on the wall of his house. He was in a pool of blood. After 10 minutes of my arrival, police came to the place of occurrence. Police seized some clothes from the house of the deceased in my presence. Exhibit 2 is my signature on Exhibit 2 seizure list. I do not know how and by whom Babar Ali was killed. Cross. On my arrival, I found 200 people present at the place of occurrence. Nearby people also gathered there. Nobody told me who killed Babar Ali. Parvina was sitting near the dead body and she was crying. Other neighboring women were consoling Parvina. Parvina and Babar had good relations. They had 3 children. The daughter of Parvina and Babar was given in marriage. There is the evidence of the PW6 to the Gaubura. But he said that nothing was, that there was no dispute in this regard or dispute regarding the relationship of the deceased at the happening. PW7, Rashidul Islam. The accused Parvina Begum is my mother, and the accused Abdul Matlib is the related brother of my father. The deceased Babar Ali is my father. The informant Amiruddin is my paternal grandfather. The occurrence took place at around 6 or 7 years back. At the relevant time of occurrence, I was in my father's house in a separate room. On the relevant night, after hearing commotion of my mother, Parvina, and my sister Irfana, I awoke from sleep and came out from my room. I found my father was lying dead on his bed. My sister Irfana told me that she noticed some person were leaving our house. My sister Irfana told me that she couldn't identify those persons, and among them one is Matlib, who is standing in the door. On hearing hue and cry, the village people also came to our house. We saw head injury of my father, and I guess that perhaps it was caused by means of axe. There was land dispute between my father and accused Matlib. I came to know from my sister Irfana that accused Matlib had killed my father. Cross. There are 2 rooms in our house. I am elder than my sister Irfana. We were in sound sleep at the 11th time. After hearing commotion, I woke from sleep, and as such, I did not see the incident. Police came and recorded my statement. It is not a fact that I did not state before the police that after hearing commotion of my mother and my sister Irfana, I awoke from sleep and came out from my room. I found my father was lying dead on his bed. My sister Irfana told me that she noticed some people were leaving out our house. My sister Irfana told me that she could identify those people, and amongst them one is Matlib, who is standing in door. I did not state that before police that my sister Irfana told me that accused Matlim had killed our father. It is not a fact that my sister Irfana did not state anything to me regarding the incident, but I have deposed falsely indicating the accused Abdul Matlim. So this is the evidence of the son, my lord, of the appellant as well as the deceased, my lord. PW8, my lord. Next one.
Yes.
I know the accused persons, Abdul PW8, Lukman Hakim India, Islam. I know the accused persons, Abdul Matlib and the wife of the late Babar Ali, who is the deceased of the case. I do not know the informant Amiruddin. It is around 4 or 5 years of the death of Babar Ali. My house is about 1.5 kilometers far from the house of Babar. One day in the morning, I came to know that Babar expired. Then I reached there and saw the dead body of Babar was lying on a bed. I saw Babar injury at the head of Babar. I came to know that Babar was murdered. I do not know who killed him. Babar is my cross. Babar is my distant relative. While I went to the house of Babar, I found many people gathered. Babar's son and daughter were also present in the house and met them. So that is the evidence of PW8 mile. PW9, doctors regarding the injury matter. On 18/4/11, I was posted at BP Civil Hospital, Nagaon, as senior medical and health officer. On that day, at about 2:30 p.m., I have performed a postmortem examination on the dead body of Babar Ali, son of so-and-so, at about 35, who is about 35 years, male, village so-and-so, Nagaon, in connection, Dumduma PS PPGB number, so-and-so, escorted by constable, so-and-so. On examination, I found rigor mortis present, one incised wound continued from left eye to left mandible, fracture left maxillary and left mandibular bone. On scalp, large inside area from frontal to parietal in left side, about 10 centimeter into 4.5 centimeter. Fracture frontal and parietal bone. Membrane rupture in frontal and parietal area. Brain matter came out in frontal, left frontal and parietal area. Opinion: in my cause, date of birth due to shock and hemorrhage as a result of head injury, which is antemortem. Injury sustained by victim is sufficient cause death. Crossman. In the postmortem report, I have not mentioned the word intracranial hemorrhage. In the postmortem report, I have mentioned the status of rigor mortis, whether ascending or descending. Stomach contains semi-solid food. This is consumed 3 to 4 hours prior to his death. External injury was not covered. Injury may have probably caused from left frontal or parietal side. Time of death is 24 hours from the time of performing postmortem. So PW10 now. Mohammed Siraj Ali. I know accused Abdul Matlib and Muhammad Parvina Begum. I know this is Babar also. Babar is Parvina's husband. I know complainant Amiruddin. Also, the incident took place about 5 years ago in the night. Around 4 a.m., I came to know about the incident. Hearing a hue and cry in Babar's house in the morning, I woke up from sleep and then came to know his house. And then I came to his house and saw Babar lying in his bed in a pool of blood. I saw cut injury on Babar's head. I saw many people in Babar's house. People have seen Parvina and Matlib roaming on bikes. I have also seen Babar and Parvina quarrel over this matter. Thereafter, Babar died. Police recorded my statement. Cross. One day I saw a quarrel that took place between Babar and Parvina. I did not see any incident. I have suspected as the village people told about it. And PW 11, Wahida Rahman. I know the accused Parvina Begum, who is present in the dock of the court today. I also know the absent accused Abdul Matlib. They belong to my same village, ward and village. I know complainant Amiruddin. I know that this is Babar Ali, who was husband of accused Parvina Begum. Babar Ali died about 4 or 5 years back from today. I heard Babar Ali was killed by someone with a spade inside his house. On the next morning, the occurrence was reported to me by my elder brother, Matiur Rahman. Having received information of occurrence, I immediately arrived at the house of Babar Ali. I saw many people gathered at the house of Babar Ali. accused Parvina Begum and the children of accused were weeping. I saw the dead body of Babar Ali lying on his bed. There was injury on his head and blood oozing out from his head and fallen on the floor under the bed. Villagers gathered there stated to me that somebody killed Babar Ali. House of Babar Ali is at a distance of 500 meters away from my house. Prior to the occurrence, Babar Ali said to me that he had land dispute with one Kazimuddin, who is the brother-in-law of accused Abdul Matlib. He also stated to me that over a land dispute, Kazimuddin and Matlib quarreled with Babar Ali. He also said to me that his wife, Parvina Begum, had illicit relationship with Abdul Matlib. He stated to me that he suspected one extramarital relationship between his wife and Abdul Matlib. Now the accused Parvina and Matlib have visiting relation with each other. Cross. When I reached the house of Babar Ali, around 300 people were gathered there. I don't know if there was any case regarding the land dispute between Babar Ali in one side and Kazimuddin and Abdul Matlib on the other side. I didn't ask Abdul Matlib about the land dispute. I don't know who had killed Babar Ali. It is not a fact that there was no land dispute between accused Matlib and this is Babar Ali. TW 12. I know the accused person standing on the dock in Mujibur Rahman. I know both the accused persons standing in the dock of the court today. Previously, I was the driver of a tractor of Moinun, who is the brother of Samiruddin. Previously, I addressed accused Abdul Matlib as Mama. I do not know the informant Amiruddin. I also do not know the victim Babar Ali. Police did not ask me anything in connection with the case leading to the death of Babar Ali. So he was declared hostile, madam. Cross, madam. It is not a fact that my previous statement before police, I stated that accused Abdul Matlib confessed before me and other people that he had killed Babar Ali some days back. It is not a fact that I stated before police that at relevant time I was working as driver in the house of Samiruddin. It is also not a fact that in my previous statement, I stated before the police that accused Abdul Matlib was hiding in the house of Samiruddin, where from police apprehended him. It is not a fact that today I am deposing falsely in favor of the accused Abdul Matlib, who happens to be my maternal uncle. Crossed by defense. Abdul Matlib is not my maternal uncle. I address him as Mama, my village courtesy. I know nothing about the occurrence. I did not make any statement before the police. I do not know if police apprehended Abdul Matlib from some place and the cause of his apprehension. PW 13. Muhammad Samiruddin. I do not know the complainant Amiruddin. About 2.5 years back, police chased one person who entered into my house. It was about 7:30 p.m. At that time, I came home after running from my shop. The accused Abu Bakr Siddiq was that man whom police chased on the relevant day, and he took shelter in my house. Some police apprehended the accused Abu Bakr Siddiq from my house. At this stage, prosecution has sought permission to declare. He also declared still because he stated another person's name, not the accused Abdul Matlib. Crossed by prosecution. It is not a fact that police interrogated the accused in presence of me and other family members. It is not a fact that the accused in our presence confessed that he had murdered Babar Ali on the relevant night of occurrence. It is not a fact that I am deposing falsely to save the accused from the consequence of crime. Crossed by defense. I do not know why the police chased the accused. The accused did not state anything before us. About 7/8 police persons came to our house. Then PW 14, madam. IO, madam. On 18/4/2011, I was posted as the IC at Dumdumia PAT under Dhing PS. On that day, one Amiruddin lodged an FIR at Dumduma PP, which was received by Dumduma PP GD number so and so, dated 18/4/2011 at 7:45 AM, and forwarded to the OC of Dhing PS for registering a case under proper sections of law. Then the FIR was received and registered under Dhing PS number so and so under dated 18/4/2011 under section 302 IPC by SI Pitender Day, the then OC of Dhing PS and enters me to investigate the case. Immediately after receiving the FIR by me, I, along with my staff, proceeded to the place of occurrence. I found the village headman and other people of Joramari at the place of occurrence, which is the head of house of deceased Babar Ali, son of Sirajul. The village headman showed me the dead body inside the house of Babar Ali. I saw a dead body on a bed, and his head was on the southern side and the legs were on the northern side and his face upside. The head was found with stab injuries and brain matter came out sleeping on several places. The house was western facing and the opening door was at the western side of the house. The house was made of bamboo wall and CI sheet roofing, and the door of the house was made of bamboo and was movable. The door was found completely in undamaged condition. I conducted the inquest on the dead body and drew sketch map of the place of occurrence.
Mark Wilson.
Exhibit 4 is the sketch map of the place of occurrence drawn by me, and exhibit 4(1) is my signature. I saw one bloodstained pillow over the head of the deceased at the relevant time of occurrence. I seized the bloodstained pillow, one banyan, one mosquito net, one bloodstained top blouse of a girl. I seized the same in presence of witness. Exhibit 2(3) is my signature. Exhibit 2, seizure list. Accused Parvina Begum, being the wife of the deceased, was arrested by me. There when I visited the place of occurrence, I was searching the accused Abdul Matlib at his house. Immediately after the occurrence, he was found absconding. On 22/4/2011, accused Abdul Matlib was arrested at Jangoni village and forwarded into village for judicial custody. Exhibit 5 is the forwarding report of accused Abdul Matlib, and exhibit 5(1) is my signature. Exhibit 6 is the forwarding report in respect of accused Parvina Begum, and exhibit 6(1) is my signature. I recorded the statement of the witnesses during the investigation. I sent the dead body of the victim to Nagaon BP Civil Hospital to conduct postmortem. After completion of investigation, I submitted charge sheet against the accused Abdul Matlib and Parvina Begum to the court. The house in which the crime was committed consists of 2 rooms only. The crime was committed on the northern room, and on the southern room, son of the deceased was sleeping at the relevant night. On the other room in which crime was committed, deceased was sleeping at the extreme side of the bed near the wall. Then his elder brother, then his wife, and then his younger daughter were sleeping cross by the fence. Before registering the case, I took up the investigation of the case, but before formally entrusted me, I went to the place of occurrence and made investigation and prepared the sketch map. I did not take signature of the village admin on the sketch map as it was not required. I have not mentioned that there are 2 rooms of the house in the sketch map. I have not mentioned in my sketch map regarding the position of the persons who are sleeping. It is not a fact that my statement with regard to the position of the person along with his in the sleeping bed on the relevant night and the bed of the other room is not true. I have not shown in the sketch map about the place where the brain matter was scattered. PW3, Habibur Rahman did not state in his previous statement before me that the accused Parvina Begum was freely mixing and loitering with the accused Abdul Matlib, which has been seen by deceased Babar Ali, and as such quarrel developed between deceased Babar Ali and his wife, for which he strongly suspected that the accused had killed Babar Ali. PW4, Irfana Khatun did not state in her previous statement before me that she had seen accused Matlib running away from this house at the relevant night of occurrence, and also did not state that her mother stated before me that Matlib had killed her father and ran away. PW4 also did not state in her previous statement before me that she had told her elder brother Rashidun that Matlib had fled away immediately after occurrence. PW4 also did not state in her previous statement before me and that she had seen Matlib and 3-4 persons fleeing away from their house immediately after the occurrence. In her previous statement before me, PW4 stated that she had seen 1 person running away who was wearing a lungi and a sadar, but she could not recognize him. PW5, Hassan Ali in his previous statement before me did not state The accused Abdul Matlib and Parvina Begum used to live together. PW7. Rashidul Islam in his previous statement before me did not state that his sister Irfana told before him that she noticed some people running from their house and she could recognize Abdul Matlib among those people. It is not a fact that I did not properly investigate the case. Re-examination by the prosecution. Exhibit 8 is the format of the FIR and Exhibit 8.1 is the signature of Sri Kitendu Day and the then OC of Ding PS, which I know. PW 13, Samiruddin is his previous statement before me that stated that accused of Matlib in presence of him and other family members confessed that he had murdered the deceased thoroughly on the relevant night. PW 12. Mazibur Rahman in his previous statement before me stated that accused Abdul Matlib had confessed before him and other people that he had killed Babar Ali some days back. PW 12 also stated in his previous statement that before me that at the relevant time he was working as a driver at the house of Samiruddin. PW 12 also stated before me in his previous statement that the accused Matlib was hiding in the house of Samiruddin, wherefrom police apprehended him. I recorded the statement of PW's Mazibur and Samiruddin during investigation. Recross examination by defense. I have not seen the deceased blood stained pillow and cloth before the court. It is not a fact that I did not meet PW's Mazibur Rahman and Samiruddin during investigation, nor I recorded the statements. So that is the evidence, Manoj, or the prosecution, Manoj. Entire evidence. So no, entire evidence, Manoj, there's nothing attributed to the appellant that she is involved in the commission of the offense, that is the murder of the deceased Manoj. The only suspicion was that by what that is also not corroborated, Manoj, that there was some relationship between this other accused and the present appellant.
It is proved.
Hello?
Trial court has recorded.
Trial court recorded, but on the basis of suspicion cannot take place of evidence. But even her own daughter and children did not say anything in this regard, my lord. They were the best persons to say in this regard, but that were because they used to stay in the house. My lord, at least they have some knowledge regarding in this regard, at least the elder daughter and son, my lord, that there was quarrel between them in this regard. But nothing is stated by them, my lord, in this regard. Even the informant has not stated by them. And land dispute theory also they have been brought in, my lord, with Abdul Matlib, my lord. On mere suspicion, she has been roped in, my lord, in this case, my lord, and convicted. And even the weapon also not seized, the weapon was used, my lord. If that weapon, any weapon was used by the present appellant, that would have been seized by because she was present in the house and the police also came and the witnesses also came immediately, my lord. Immediately all persons arrived. And PW4 is a star witness, my lord, in this case, my lord, so because he was sleeping with the deceased, my lord, but he has not stated anything. Neither even I'll just statement subsequently stated, my lord, in the evidence against Abdul Matlib, by the party. So what is appellant is concerned, my lord, nothing is attributed against her. Neither has stated any relationship or quarrel between them, my lord.
In Rathi, the concept is
No, sure.
how to do it.
My lord. Para 21.
Huh?
Para 20.
Where are 8 or what?
Para-
Mhm.
91 yes.
And considering all these aspects, my lord, that last week, well in my appearance, she has 3 children, also my 2 daughters and so on, my lord. So that aspect may also be considered.
The concept of 34.
It's common intention. Yes. Intention must be there, but that is really. Acts done by several persons in further of sense of common intention.
Now, what are the necessary ingredients?
Whenever criminal act is done by several persons in furtherance of here. Well, two persons, one is acquitted by law. So, each of such person is liable for that. When an incident takes place, my lord, when several persons are present, even not doing anything also, he sometimes he may also be charged by law. The intention must be there, but that is. One condition is that at least two, there should be two or more accused, but that I have. To apply section 34, apart from the fact that there should be two or more accused. Two factors should be must be established: common intention and participation of accused in commission of an offense.
How Trimukh Maruti Pilcon comes into play?
Yes, your lordship.
How?
The wife of the present appellant. She is the wife of the victim. She was an inmate of the house. Lordship, but the other person who has played away, Lordship, he was not your lordship, but she is the inmate of the house and she is admitted in 313. She was present. So there's an explanation is required from her, your lordship. But total denial, my lord. And your lordship,
When this Trimukh Maruti Pilcon comes into play,
when the incident is taken place inside the four corners of the house.
and there are nobody else except the accused,
That is there,
along with the deceased.
my lord.
Here is a case, elder son is there. And the daughter was there also inside the room. It is not a case of Trimukh Maruti.
No, your lordship. Inmates
Have
of
you
the house.
read?
Yes, inmates of the house. Not
Have you
only,
read Trimukh
yes,
Maruti?
I have, my lord. Let us
have
see.
a look.
Lordship,
We'll come back.
my lord.
Oh,
Lordship, para 15. Where an offense like murder is committed in secrecy inside a house, the initial burden to establish the case would undoubtedly be upon the prosecution. But the nature and amount of evidence to be laid by it is to establish the charge cannot be of the same degree as is required in other cases of circumstantial evidence. The burden would be of a comparatively lighter character. In view of Section 106 of the Evidence Act, there will be a corresponding burden on the inmates of the house to give a causal explanation as to how the crime was committed. The inmates of the house cannot get away by simply keeping quiet and offering no explanation on the supposed premise that the burden to establish its case lies entirely upon the prosecution and there is no duty at all on the accused to offer an explanation.
It made there were 3 inmates.
Yes, but they have offered. Dr. PW.
Their mother was weeping. Their mother was weeping beside the dead body of her husband. The other 2 inmates have offered explanation,
Yes.
the daughter as well as the son. They have offered explanation.
Son was
Our
sitting in the
mother-
next room. Son was sitting in the next room.
After hearing his sister's call, he went there and found his mother weeping beside the dead body.
No, she was there, but why she kept mum, my lord?
What?
She
She is weeping, but why?
no, my lord, under 313, your lordship, her presence was well proved. She was very much present there, along with the other child witnesses. But she did not owe any explanation, my lord. And whatever she is told that Abdul Muttalib had killed, she kept mum. And prior to the incident, your lordship will kindly note the time of incident, 1:30 a.m. She was found to be roaming with that accused person.
At 1:30 p.m., there is no way in the evidence from where, my lord.
1:30 AM, your
Where
lordship,
is Mr.
PW three.
She was in the
PW
room.
three. PW three,
Okay, we'll come back.
yes. I was relying on Trimukh Marty, my lord.
Ah.
Where are
Yes,
you?
Mr. Hazarika, I can see.
Para 18, your lordship,
Right.
my lord. The question of burden of proof where some facts are within the personal knowledge of the accused was examined in state of West Bengal versus Mir Muhammad Omar. In this case, the assailants forcibly dragged the deceased Mahesh from the house where he was taking shelter on account of the fear of the accused and took him away at about 2:30 in the night. Next day in the morning, his mangled dead body was found lying in the hospital. The trial court convicted the accused under 364 raid with 34 IPC and sentenced them to 10 years RI. The accused preferred an appeal against their conviction before the High Court, and the state also filed an appeal challenging the acquittal of the accused for murder of Charles. The accused has not given an explanation as to what happened to Mahesh after he was abducted by them. The learned Sessions, after referring to the law on circumstantial evidence, had observed that there was a missing link in the chain of evidence after the deceased was last seen together with the accused person and the discovery of the dead body in the hospital, and had concluded that the prosecution had failed to establish the charge of murder against the accused persons beyond any reasonable doubt. This court took note of the provisions of 106 of the Evidence Act and laid down the following principle in para 31 to 34 of the reports. The pristine rule that the burden of proof is on the prosecution to prove the guilt of the accused should not be taken as a fossilized doctrine, as though it admits no process of intelligent reasoning. The doctrine of presumption is not alien to the above rule, nor would it impair the temper of the rule. On the other hand, if the traditional rule relating to burden of proof on the prosecution is allowed to be wrapped in pedantic coverage, the offenders in serious offense would be the major beneficiaries and the society would be the casualty. In this case, when the prosecution succeeded in establishing the aforenarrated circumstances, the court has to presume the existence of certain facts. Presumption is a course recognized by the law for the court to rely on in conditions such as this. Presumption of the fact is an inference as to the existence of one fact from the existence of some other facts, unless the truth of some inference is disproved. Presumption of facts is rule of law of evidence that a fact otherwise doubtful may be inferred from certain other proof facts. When inferring the existence of a fact from other set of proof facts, the court exercises the process of reasoning and reaches a logical conclusion as the most probable position. The above principle has gained legislative recognition in India when Section 114 is incorporated in the Evidence Act. It empowers the court to presume the existence of any fact which it thinks likely to have happened. In that process, the court shall have regard to the common course of natural events, human conduct, etc., in relation to the facts of the case. When it is proved to the satisfaction of the court that Mahesh was abducted by the accused and they took him out of that area, the accused alone knew what happened to him until he was with them. If he was found murdered within a short time after the abduction, the permitted reasoning process would enable the court to draw the presumption that the accused had murdered him. Such inference can be disrupted if the accused would tell the court what has happened to Mahesh, at least until he was in their custody. Applying the aforesaid principle, this court, while maintaining the conviction at 364 Radio 34 IPC, reversed the order of acquittal under section 302 Radio 34 IPC and convicted the accused under the state provision and sentenced them to imprisonment for life. In Ram Ghulam Chaudhary versus State of Bihar, the accused, after brutally assaulting a boy, carried him away, and thereafter the boy was not seen alive nor his body was found. The accused, however, offered no explanation as to what they did after they took away the boy. It was held that, for the absence of any explanation from the side of the accused about the boy, there was every justification for drawing an inference that they had murdered the boy. It was further observed that even though Section 106 of the Evidence Act may not be intended to relieve the prosecution of its burden to prove the guilt of the accused beyond reasonable doubt, but the section would apply to cases like the present, where the prosecution has succeeded in proving facts from which a reasonable inference can be drawn regarding the dead. The accused, by virtue of their specific knowledge, must offer an explanation which must lead the court to draw a different inference. In a case based on circumstantial evidence where no eyewitness account is available, there is another principle of law which must be kept in mind. The principle is that when an incriminating circumstance is put to the accused, and the said accused either offers an explanation or offers an explanation which is bound to be true, then the same becomes an additional link in a chain of circumstances to make it complete. This view has been kept in Catanam decisions of this court. Lordship, so my submission is that, my lord, she kept mum. She could have offered an explanation, my lord, how the other accused person, how he killed him and what happened. And your lordship, two of the witnesses, PW3 and my lord, PW10, they have stated, my lord, that the accused person was seen, present accused person was seen, and the other person, other accused who was acquitted, my lord. Lordship, may kindly have a look at the evidence of PW3, my lord. Last portion in cross-examination. Page 14. It is not a fact that I did not state before the police that before the incident, the accused Muttalib and Parvina were found roaming by Babar Ali, and out of this there was a quarrel took place between Babar and Parvina, and I have suspected that due to the quarrel and relation, the accused persons killed my brother Babar. And the other witness, minor PW10. In page 31. Lordship, third line, page 31. People have seen Parvina and Muttalib roaming on bike. I have also seen Babar and Parvina quarrel over this matter day after Babar died. Lordship, the time of occurrence is 1:30 a.m., midnight. Lordship, they were having relation. They had land dispute, my lord. And apart from that, this accused
This lady,
no, with the husband.
Motleb and
Deceased.
disease
Yes.
perhaps had a land dispute. So
And
that,
had a
that
relation
might
also,
give-
my lord.
that might give a motive for Motleb to say commit the crime.
Lordship,
Now the linking with Motleb is sought to be made on the basis of some extramarital relationship. Now, what kind of extramarital relationship? Let us see specifically, let us see specifically who has put the allegation of extramarital relationship.
PW3, my lord.
Three.
He only his evidence, and 10 said the people had seen.
Three.
Lordship,
Them three men.
PW5 also.
Let us
PW5.
say one by one.
Five only.
Yes.
One by
I'm
one.
sorry. I'm sorry, madam. PW3,
One by one.
my lord.
But with whom, my lord? That was-
I have a suspect. So
Hmm.
suspicion. Suspicion is not proven. I have a suspect. It should be suspicion. In my mind, nobody can stop what is cooking in somebody's mind.
Lordship,
Come to page
30, 13.
13, 1, 3.
yes.
No, you are alleging extramarital affair. Now, fourth line from bottom.
I have a suspect in my mind that
In
before.
my mind, what is cooking in somebody's mind, nobody can prevent. Before the incident, Babar Ali found the accused and were roaming. Regarding this, there was a quarrel took place between Babar and his wife Parvina Khan. I have suspected that out of this quarrel and relation, my cousin Babar was killed. I strongly suspect that the accused Muttalib and Parveen killed Babar. Right? This is three suspicion.
Three suspicion.
Then next.
Page 14.
Page.
Cross examination also.
What is it?
Same.
I suspected that due to the quarrel and relation, the accused to kill my brother.
Huh?
Third paragraph, last line. second paragraph, last line.
Don't-
cross-examination.
This cannot be taken into
Ah.
account.
That is contradiction.
No, Lordship, as a whole, it should be taken, my lord. Evidence should be taken as a whole. My submission is that the killing part may not be, your lordship may discard it because it is a suspicion. Regarding the relationship part, at 1:30 midnight, somebody roams around, my lord. Yes, time of incident, my lord,
No, 1:30.
Oh,
where it stopped.
madam,
1:32 AM.
The roaming around.
the roaming around, where is that?
She was in the room. man.
Be careful,
Lordship, somewhere at that time
be
it's written.
careful.
Lordship. Before the incident taken place
Before someday. Where have you got?
here,
Be careful.
before the incident, Lordship, then let us see the evidence of PW10 once.
At page number?
Lordship, I'll take your lordship. PW10,
Page 30.
PW10. Time not there, I'm sorry. Timing not there. Lordship, one more witnesses have said regarding the relation.
That is.
PW3, PW3. Not PW3, my lord, one more.
PW11.
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 My lord.
That disease told this witness that disease suspected extramarital relationship of his wife with Abdul Muttalib. The disease himself suspected.
Four line two. Two line two, four line two. Or four line two.
His wife.
He also stated that.
His wife had
Oh.
illicit.
Oh,
That he, that was the next door.
service
He stated to me that he suspected.
suspected.
Suspected. The disease himself suspected.
No, time is not there.
Not there.
But the
This
relationship-
PW3 has said he found the disease and, the Motlib and this accused
My lord.
roaming around. That is what he has said. Very omnibus allegation.
My lord.
Somebody said Motlib and Babur had land dispute.
Lordship, PW.
And it might be a motive for Motlib. But that motive with that suspicion has been transferred
My
to
lord.
this particular accused. And the conduct of the accused is not very strange. She was found, let us see PW3's daughter's evidence. Four.
Yes,
At that
15.
time, I woke up from sleep after hearing my mother's cry. Saw that sitting next to my father, my mother was crying loudly. Is it so strange?
Lordship, third person,
That is
Lordship,
not-
either she has to commit the crime or somebody else as a normal human being, reasonable person, Lordship, in the sense, my lord, she'll make hue and cry that neighbors will arrive, your Lordship.
Only the person of the son.
Son, my
She could have
lord.
threatened her daughter, my lord, not
Son,
to say anything.
PW7.
I also found like cases, my lord, where the threatening is used, but not to, so that done, she has not revealed.
PW
Son is-
That
PW7.
is not there.
Huh?
PW7.
PW7. He is not that young. He was
Yes.
18
He
when
was
he
sitting in
deposed.
another
When he
room.
Another
deposed.
room. Immediately he was informed.
When he deposed.
Yes.
And what did he say?
He said The accused Parvina,
Hearing commotion of my mother. Mother was making commotion and my sister. I awoke from sleep and came out from my room. When this evidence is available, as regards the accused, son and daughter, they are saying the mother was crying. Then what kind of Trimukh Mardi Kirkon will come into play?
then why, Lordship?
Come into,
Yes, my lord, they offered explanation, but what about
they
the
have itself offered the explanation.
PW7, my lord, he arrives subsequently because he was
Same,
sleeping in another room,
Come to IO.
my lord. IO is PW14.
If you want description of the house, come to the IO. That was a question put by the court to the IO
My lord.
39.
Page 39,
To court,
yes.
the house in which the crime was committed consists of 2 rooms only. The crime was committed on the northern room, and on the southern room, the son of the deceased was sleeping at the relevant time. On the other room in which the crime was committed, the deceased was sleeping at the extreme side of the bed near the wall. Then his elder daughter, then his wife, then his younger daughter were sleeping. So it is a 2-room house, not a big house.
Lordship,
If you want to get more support, let us have the
sketch map,
sketch map,
page 80.
page 80. This is the house.
PO is the wooden,
Bamboo door.
revised bamboo.
Wooden bed, place of occurrence. A raised bamboo platform, wooden bed. Wooden door. It is a 2-room wooden house made of bamboo. Now, it is not that the room where the son was sleeping was at a far distance. It was in the next. The conduct of the accused, she was crying and wailing. Both the daughter and the son, they have testified.
Lordship, deposition of the son, my lord. So after hearing hue and cry, Lordship, he went there. So subsequently he came to know, not immediately.
How much? Then what the daughter says to him, PW son,
PW7, my lord.
7, what his sister said. My sister Irfana told me that she noticed some people were leaving our house. My sister told me that she could identify those people, and among them one is Motlip, who is standing in the door. Right, this part, he said. Her sister said to him, and Motlip was acquitted already.
My lord.
And where is the inference to bring 34?
No,
What are the circumstances to bring 34?
since the
Because
other accused,
she is not the assailant. That is clear. Where is the circumstance to bring into operation section 34?
Lordship, the evidence of PW4, although the other coordinate bench has discarded her evidence, my lord, but she has stated like PW4, the daughter,
Ah.
that Motolip came out, Lordship, and your Lordship, in your presence, your husband is assaulted by somebody, whoever is. Lordship, she will, Lordship, there's no reaction,
It is
no
repeated-
retaliation.
it is Repeated or not? Let us see the
Evidence of
evidence of PM report.
a PM report.
It is repeated assault or one?
Lordship, let us see. Lordship, on space 75. One incised will continue from left eye to left sensor.
Only mandible.
Fracture left maxillary left mandible bone.
Basically, it is one area,
One,
one area.
Fatal, one fatal injury.
It is not that repeated and see one blow,
was so
Assailant-
fatal, my lord, it
assailant
like
quickly
chopped off,
retreated.
chopped off his head, my lord. It
Who?
was lying down.
Who? Where is that?
Lordship, it's there.
Some
Not
witness
October.
is saying, but let us see the autopsy, doctor.
Autopsy doctor,
Brain matter
PW9,
coming out of left parietal and frontal area.
PW9, my lord.
Brother,
Brain matter came out in left front.
In that circumstances, that person is acquitted. Now this appellant is roped in with the aid of 34.
34.
Now common intention should be there. Now, what kind of common intention? That is not very palpable.
Clear, yes.
This is not a case of criminal conspiracy. To draw also inference of criminal conspiracies, prior concert. Similarly, meeting of mind should be there. And this has to be drawn from circumstances which are proved. Somebody suspected, even the husband suspected. Somebody might have a good relation,
Lordship.
but it depends on the eyes of the beholder,
Yes.
how he sees things.
Lordship.
That way the village.
It is not a case of catching them red-handed. Roaming at a public road or
No, by.
going together. Roaming is one word, but
Lordship,
going-
another point, she used to reside with him. It has come up on record, my lord.
he clearly denied it
No, Lordship.
in 13. I know Motley only by face. I did not go to his house. Question number 5. Instant criminal appeal. Under section 374, within bracket 2, comma, Code of Criminal Procedure 1973, within bracket, the CRPC order code for short is directed against a judgment and order dated 27/10/2017, passed by the Court of Learned, Additional Session Judge number 1, Nagaon, Assam, within bracket, the trial court for short, in sessions within bracket T1 bracket close, case number 361 within bracket capital N bracket close stroke 2012. Full stop. It is pertinent to mention that two accused persons, including the present accused appellant, stood the trial in sessions case number 361 stroke capital N of bracket capital N stroke 2012. For a charge under section 302, Indian Penal Code bracket IPC, read with section 34, IPC. By the judgment and order dated 27/10/2017. both the accused, including the comma, have been convicted under section 302 IPC, read with section 34, IPC. Full stop. Para. We have heard Mr. I.A. Hajorika, learned counsel for the accused appellant, and M.S. B. Bhuya, learned additional senior counsel and additional public prosecutor, Assam, assisted by M.S. M. Chakraborty, learned counsel for the respondent state. Para, Mr. Hajorika, learned counsel appearing for the accused appellant, has submitted that the other accused person, Muhammad Abdul Mottalib, subsequent to the judgment and order of conviction and sentence passed in sessions case number so and so, had preferred an appeal independently, and the same was, said criminal appeal was registered and numbered as criminal appeal number 37 stroke 2018. Full stop. By judgment and order delivered on 22/04/2019 in criminal appeal number 37 stroke 2018, Muhammad Abdul Mottalib has been acquitted by a coordinate bench of this court, finding his conviction under section 302 IPC, read with 34 IPC, unsustainable in law. With the acquittal of the said co-accused, Abdul Mottalib, who stood the trial with the present accused appellant, the Spectre, SPECTRE, of section 34, IPC stood removed submitting further, Mr. Hajorika has contended that there is no evidence, not to speak of any cogent and reliable evidence, to rope in, ROPE, the present accused appellant for the murder of her husband, murder of the deceased, who was incidentally the husband of the accused appellant, with the aid of Section 34 IPC. Full stop. It is contended that there was no eyewitness to the incident, though incident of assault. Full stop. Which occurred inside the dwelling house of the deceased and the accused appellant. Full stop. At the time of the incident, comma, apart from the deceased and the accused appellant, comma, there were a son and a daughter, two daughters of the deceased and the accused appellant who were present. Full stop. The incident had occurred midnight hours. Full stop. The learned trial court has convicted the accused appellant on the basis of testimonies of some of the prosecution witnesses who suspected an extramarital relationship between the accused appellant and the co-accused, comma, who already stood acquitted. Full stop. In the absence of any motive, comma, the accused appellant could not have been convicted with the aid of Section 34 IPC merely on the basis of suspicion. In such view of the matter, comma, the impugned judgment and order of conviction and sentence is not sustainable insofar as the accused appellant is concerned. Full stop. Para. Par contra, as we are learned additional public prosecutor has contended that the incident of murder had occurred inside the dwelling house of the deceased and the accused appellant, comma, that too in and around midnight. Full stop. Being an inmate of the house, comma, it was incumbent upon the accused appellant to offer a plausible explanation as to how the incident had occurred. Full stop. Incident had occurred. Full stop. The learned trial court has recorded a finding that the extramarital relationship between the accused appellant and the co-accused was established from the evidence on record. And since the co-accused had a land dispute, comma, there was a clear motive on the part of the accused, co-accused, to perpetrate the crime on the disease, to perpetrate the crime of murder. And the accused appellant bore an affinity to the co-accused. Full stop. In such view of the matter, comma, the learned trial court has rightly reached the finding that both the accused persons in furtherance of their common intention and common motive committed the murder of the deceased on the fateful night when the deceased was sleeping in his bed inside his house. Full stop. MS Bhuya has further submitted that even if the co-accused has been acquitted of the charge of murder, comma, the evidence on record qua the charge of murder with section 34, IPC are to be independently assessed insofar to consider the case against the accused appellant. Full stop. If viewed independently, comma, the evidence stroke materials on record go to indicate that the accused appellant who was involved with the co-accused in perpetrating the crime. Full stop. Yes, anything?
That is.
Full stop. Para. We have duly considered the submissions of the learned counsel for the parties and have also perused the materials available in the case records of sessions case number sessions T1 case number. लिख दिए वो. Full stop. Para. The case of the prosecution was set in motion with the institution of a first information report by one Muhammad Amiruddin within bracket PW1 before the in charge, Dumdumia Police Outpost on 18/4/2021. Full stop. On receipt of the said FIR, the in charge, Dumdumia Police Outpost registered the same General Diary entry number 256 dated 18/4/2021 and took up the investigation of the case, while forwarding the FIR to the officer in charge, Think Police Station for registering a case under proper sections of law, full stop. On receipt of the FIR, the officer in charge, Thing Police Station registered the same as Thing Police Station case number 94/2011 on 18/4/2011 for the offense of murder, for the offense under section 302, IPC, full stop, para. In the FIR, the informant, BW1 had stated that at about 1:30 a.m. in the night intervening 18/4/2011 and 19/4/2011, some unidentified miscreant killed his nephew, Babar Ali, by stabbing on his head with a sharp weapon, while Babar Ali was sleeping on bed. Full stop. The informant further stated that when he rushed into the house of Babar Ali after hearing hue and cry of the children of Babar Ali, he saw the dead body of Babar Ali lying on the bed. Full stop. Para. Looks nonsense, I hope. Ayo?
PW 14.
From the materials on record, it has emerged that after registering General Diary entry number 256 at 7:45 a.m., the IO of the case, PW 14, along with his staff, proceeded to the place of occurrence. That is the house of the deceased. Full stop. On reaching the place of occurrence, he saw the IO PW 14 saw the dead body of the deceased on the bed with stab injuries and brain matter coming out. Full stop. The brain, full stop, no, like. The house of the deceased was made of bamboo wall and CI seed roofing. The door of the house was made of bamboo and was movable. Full stop. The inquest on the dead body of the deceased. Where is the inquest report? Exhibited, not exhibited. Exhibited or not exhibited?
No. It's not them.
Huh? According to the IO PW 14, he conducted inquest on the dead body of the deceased at the place of occurrence itself and drew a sketch map of the place of occurrence, a wide EXT4 Full stop. He seized a number of materials. Provide exhibit EX2, CGI list. Full stop. The accused appellant was found at the place of occurrence and she was arrested on that day himself. Full stop. The other co-accused, the co-accused, Abdul Muttalib, was arrested on 22/04/2011. Full stop. During the course of the trial, the forwarding reports in respect of the present accused appellant and the co-accused, Abdul Muttalib, were exhibited as EXT 6 and EXT 5 respectively. Full stop. The statements of the witnesses were recorded under section 161 CRPC by the IO. Full stop. The dead body was thereafter sent to the BP Civil Hospital, for performing post-mortem examination. Full stop. The post-mortem examination of the dead body of the deceased was performed at BP Civil Hospital, Nagaon, on 18/4/2011 by the
PW9.
by the senior medical and health officer, Dr. Bhupen Chandra Bora, within bracket PW9, who was posted at BP Civil Hospital, Nagaon, on that day. Full stop. The autopsy doctor, PW9, after performing postmortem examination on the dead body of the deceased, submitted the PME report, which was exhibited during the trial as EXT 3. Full stop. The IO of the case, after completing the investigation into so-and-so case number, submitted a charge sheet under section 173 to CRPC. Provide charge sheet number charge sheet exhibited or not exhibited?
It's 87,
87.
exhibit 7,
By charge sheet number
11.
104/2011 on 39/2011, finding a prime case for the offenses under section 302, IPC, read with section 34 IPC against the two accused persons, VIJ, the present accused appellant, and the co-accused, Abdul Muttalib. Full stop. Para. Corresponding GR case number bracket FIR to. FIR to case number 2 আছে না? Case number corresponding GR case number is 1111/2011. On submission of the charge sheet, comma, the capital court of what is the code? Committal code.
Lordship 510, page 7.
Don't know the code.
Court is
Committal code. Secured the appearance of the two accused persons on 5/10/2012. First off. The accused persons were furnished the copies in terms of the provision contained in section 207 CRPC, closed off, as the offense under section 3, IPC is exclusively, oh, I'm sorry. We'll come back. I did not notice the clock.
Exhibit 7.
It is not there in the evidence of PW 14. The IO.
Lordship, I'll go through it. Sheet was submitted by the same IO. I've seen. PW 13. His signature is there in the charge sheet. His signature is there in the charge sheet.
Exhibited, whether he
Oh,
exhibited,
no, it's not. It hasn't come up on record. My Lordship, I'll see in the list of exhibits then.
So it is there, but who had exhibited?
It is not there on record,
It is not in the evidence of IO.
my lord. It's not there.
oh,
Sorry.
exhibit 7 in the list of exhibits it is there, but IO
11.
is 40. Nine. Submitted the charge sheet 9. What is it? Never mind. Evidential. 18. 18 the question. Yes, evidence. Yes,
Or evidence.
yes.
Will you present section? Evidence for the case. And also. Evidence of IO. IO, my lord. It's not there, I've seen. And his signature was also there. It's not the type, it's a type copy.
By allowing the accused persons to remain on bail previously, comma, and notifying the public prosecutor, one, the case record of their case number 1111/2021 was forwarded, were forwarded to the Court of Sessions, Nagaon. Fixing 12/10/2012 for appearance of the accused persons before the Court of Sessions. Full stop. After receipt of the case records of ZR case number so and so, pursuant to the order of commitment dated 5/10/2012, the London Court of Sessions registered the same as Sessions case number 361, so and so. Post of para. During the course of the trial, no, after, on, 9/5/2013, the learned, sorry, the case was thereafter sent to the learned additional session judge, Nagaon, for disposal. Post of. On 9/5/2013, the learned trial court framed the following charge, page 16 of, page 16 paper book A to A. When the charge was read over and explained to the accused persons, they pleaded not guilty and claimed to be tried. Full stop. During the course of the trial, the prosecution side to bring home the charge against the accused persons, examined the following witnesses, following prosecution witnesses, page 71, 1, 2, 3, 4 case withdraws. And exhibited the following documents. 1, 2, 3, 4, page 71. Full stop. Para. Who were declared hostile?
Hostile PW 12, PW 13. আর ওগুলো চলছে না, না? 12 টা বাজে।
দুজনে আছে। 12,
12 and 13 না।
12 and 13.
During the course of the trial, the prosecution declared two witnesses, that's PW 12 and PW 13, as hostile and sought permission of the learned trial court, and the learned learned public prosecutor sought permission from the learned trial court to cross-examine the said two witnesses. On permission being granted, the prosecution side cross-examined PW 12 and PW 13. With regard to their previous statements made before the police. However, the prosecution did not bring out any contradiction in as part of procedure laid down in section 145 and section 154 of the Evidence Act, read with section 162 CRPC. Full stop. In any view of the matter, PW2 and PW, 12 and PW 13 did not say anything as regards the present accused is concerned. They did not say anything about this. Full stop. Para. PW1. Was an uncle of the deceased. And he deposed that he knew both the accused persons. Full stop. PW1 stated that his house was situated near the house of the deceased, intervened by a road, full stop, on the relevant night, at about 1-00/1-30 AM. He went to the house of the deceased on hearing hue and cry from there. Full stop. Going there, he entered inside the room, finding the door of the house open. Full stop. Going inside the house, he found the daughter and the son of the deceased, that is, PW4 and PW7. There, who told him that their father, Babur Ali, was murdered, but they did not say to him who had murdered their father. Full stop. Then, PW1 went near the body of the deceased, saw one head injury on the body, which was caused by a sharp weapon. Full stop. PW1 also found the accused appellant near the dead body. Sitting near the dead body. Full stop. Then he raised alarm, and hearing his alarm, people from the neighborhood gathered at the place of occurrence. Full stop. PW1 further stated that he lodged the FIR on the following morning. Full stop. PW1 further stated that he did not know how Babur Ali died. Full stop. He exhibited the FIR as EXT1 with his signature therein as EXT11. Full stop. In his cross-examination, in his cross-examination, PW1 admitted that he did not know who killed the deceased. Full stop. He further stated that none of the persons who gathered at the house of the deceased after the incident could say to him how the death had occurred. Full stop. He further stated that in his FIR, he mentioned that some unknown miscreants had killed Babur Ali at night. Full stop. PW2 was another uncle, was also an uncle. No, PW2. Sorry. The deceased, Babur Ali, was a nephew of PW2, who knew both the accused persons. Full stop. Narrating about the incident, PW2 deposed that at the relevant time, he was in his house, which situate at a distance of 100 meters from the house of Babur Ali. Full stop. At about 1:30 a.m., PW1 came to his house and told him that Babur Ali had been killed. Full stop. Then PW2 rushed to the place of occurrence along with PW1. Full stop. There, he saw Babur Ali lying dead on his bed in a pool of blood, oozing from an head injury. Full stop. Seeing the position of the dead body, he suspected that Babur Ali was caught by someone and killed by another person. Full stop. PW2 stated that at that time, the present accused appellant and the children were present. Full stop. PW2 testified that he did not know how Babur Ali died. And he was also not told by anybody how he died. Full stop. In his in his cross-examination, PW2 testified that he did not know how the incident took place. PW3 next. PW3 was a cousin of the co-accused, Abdul Muttalib, and he knew the present accused appellant also. Full stop. And the informant, PW1. Full stop. As regards the incident, he stated that the incident occurrence took place at about 1:30-2 a.m. on 18/4/2011. Full stop. At that time, he was in his house, which was at a distance of 100 meters from the house of the deceased. Full stop. On hearing commotion raised by the children of the deceased, he came to the place of occurrence and saw the dead body of the deceased lying on his bed. Full stop. According to him, the disease was killed by with sharp pointed weapon, and there was bleeding from the head. Full stop. He, PW4 3 admitted the presence of the accused appellant there, as she was found sitting near the dead body of her husband, found sitting and weeping near the dead body of her husband. Full stop. PW2 4 3 further deposed that when he asked PW4, that is the daughter of the deceased, regarding the incident, he was told that PW4 saw someone going out of their house. But she could not name the assailant and recognize any person. Full stop. PW3 expressed a suspicion that before the incident, the deceased found the two accused persons roaming and regarding the same command, a quarrel took place between the deceased and the accused appellant. Full stop. He further, yes, PW3 also deposed that he suspected that out of the said quarrel and relationship, the two accused person had killed the deceased. Was the subfera in his cross-examination, PW3 admitted that he did not know how the incident took place, as he did not see the incident. Full stop. He further stated that he did not have any knowledge who killed the deceased. Full stop. Though suggestions were put to this witness as regards the previous statement, after his specific denial, the defense did not bring the previous statement or any part of the previous statement for the purpose of bringing out any contradiction. Full stop. 4. PW4 was the daughter of the deceased, and she was present inside the house at the relevant point of time. At the time of the incident, along with the present accused appellant and her elder brother. Full stop. This Babur is Jetha or what? No, one of the accused is my mother and one is my Jetha, my father's elder.
Wait, one of the
Yes,
accused is the
Mokali.
mother and one is, what is the elder? His father's brother. They are related.
Okay. PW4 testified that the co-accused was an elder brother of her father. Full stop. PW4 stated that the incident took place on a night when she was sleeping with her father. Full stop. At that time, she woke up from sleep after hearing her mother's cry and saw that sitting next to her father, that is, the deceased, her mother was crying loudly. Full stop. She further stated that the co-accused, she further stated that she saw the co-accused going out from their room along with 3-4 other persons, but she could not recognize any of them. Full stop. PW4 further deposed that when she asked her mother, she was told that the co-accused killed her father and ran away. Full stop. PW4 saw an injury on the head of her father. Full stop. Then she called her elder brother, comma, PW7. Full stop. PW7 was told that the co-accused fled away from after killing her father. Full stop. Hearing hue and cry, comma, the people from the neighborhood, persons from the neighborhood gathered at the place. Full stop. In her cross-examination, comma, PW4 stated that she, along with her sister and parents, slept on the same bed on the night of the incident. Full stop. As regards the house, comma, PW4 stated that the room where her father and she slept was the first room. Full stop. At the same time, comma, PW4 stated that her elder brother, her room, was the first room. Full stop. Suggestions were put to PW4 by the defense, and those suggestions were denied by PW4. Full stop. Para. PW5 and PW6.
Six is the Dalgura.
Was an article of the disease. PW4 5 stated that at around 3:00 AM, he woke up from sleep on hearing hue and cry and went to the house of the deceased. Post of going there, comma, he found the deceased lying on his bed. Post of this witness stated that he found the head of the deceased in two parts with brain particles lying scattered in and around the bed. Post of. At the place of occurrence, comma, PW5 found the present accused appellant sitting near the dead body of her husband. Full stop. At that time, comma, many people gathered at the place of occurrence. Full stop. He stated that he had knowledge about a land dispute between the co-accused and the deceased, and he guessed that both the accused persons had killed the deceased. Full stop. He was a seizure witness to the seizure list, comma, EXT 2. Full stop. When a question was put to PW5 as regards his guess, comma, PW5 replied to the court by stating that he noticed that the co-accused used to roam with the present accused appellant. And over that issue, the deceased had a dispute with the present accused appellant. Subpara. In his cross-examination, PW5 admitted that he did not see the incident. PW5 stated that apart from the FIR lodged by PW1, there was another FIR which was lodged by one Habibur, as he accompanied Habibur while lodging the FIR. Full stop. Within bracket. No F. Other than EXT1, FIR, no FIR was exhibited before the trial court. Bracket close. Full stop. PW5 Fire stated that he saw the accused persons roaming together in and around the village, and denied the suggestion that he had stated falsely that the accused persons used to roam together. PW6 knew both the accused persons as they were co-villagers. He also knew the informant, PW1, and the deceased. Full stop. In his evidence in chief, PW6 stated that it was in the morning hours of 18/4/2011, he heard that somebody had killed Babar Ali. Full stop. Then he went to the house of Babar Ali and found the dead body of Babar Ali on the bed inside his house. Full stop. There was a cut mark on the neck of Babar Ali with and the dead body was in a pool of blood. Full stop. He was a seizure witness. He was a witness to the seizure list, EXT2. Full stop. In his cross-examination, PW6 stated that when he went to the place of occurrence, there were already about 200 people present there. Full stop. But none of them had told him as to who killed Babar Ali. Full stop. PW6, like the other witness, found the present accused appellant sitting and crying near the dead body of her husband, and the women from the neighborhood were consoling the present accused appellant. Full stop. PW6 testified that the deceased and the present accused appellant had good relations and they had 3 children. Full stop. PW7 was the son of the deceased and the present accused appellant. Full stop. Narrating about the incident, PW7 deposed that he was in the house at that point of time in a separate room. After hearing commotion, alarm raised by his mother, that is the present accused appellant, and his sister, PW4, he woke up from sleep and came out from his room. Full stop. He found his father lying on his bed. Full stop. Then, PW4 told him that she noticed some people leaving their house. And she could identify those people, one of whom was the co-accused. Full stop. Having seen the head injury on the body of his father, he guessed that it was caused by an axe. Full stop. PW7 also stated, had also referred about a land dispute then existing between his father and the co-accused. Full stop. PW7 stated that it was from PW4 only he came to know that the co-accused had killed his father, full stop. Subpara. In his cross-examination, PW7 stated that there were 2 rooms in their house. Full stop. It was hearing alarm. He woke up from sleep, but did not witness the incident. Full stop. Suggestions were put to this witness by the defense, and this witness denied those suggestions. Also, para. PW8 was a neighbor. No, was a deposed that hearing the news of death of Babar Ali, he went to the house of the deceased and found the dead body of Babar Ali lying on a bed with a head injury. Full stop. He stated that he did not know who killed Babar Ali. Full stop. In his cross-examination, PW8 stated that both the son and the daughter of Babar Ali were present in the house when he went to the house of Babar Ali. Full stop. Para. PW9 was the doctor who performed the post-mortem examination on the dead body of Babar Ali on 18/11/2011. Full stop. On and made the PME report within bracket EXT 3. Full stop. In the PME report, he reported the following injuries. He reported that page 75 or 75. B star দিব মাজে মাজে এইখিনি দি দিব এইখিনি দিব পেন্সিলেৰে দিছো মই যিখিনি আছে বাকীখিনি star দি দিব এইখিনি নালাগিলে দি দিম page 75 76 or mark কৰাখিনি brain matter rupture এনেকে দি দিছো meeting value up to 78 or lower, more detailed description as an opinion. PW 9 stated that the injury sustained by the victim was sufficient to cause death. First one. In his cross-examination, PW 8 stated that the external injury was not carved and the injury might have probably been caused from left frontal or parietal side. Pusto. Para. PW10. Stated that on the date of the incident, he was in his house sleeping, full of hearing hue and cry from the house of the deceased. In the morning, he woke up from sleep and went there. First of going there, he saw Babur Ali lying on his bed in a pool of blood with a cut injury on his head. Full stop. He saw many people at the place of occurrence. Full stop. He deposed that apart from him, many persons had seen the accused persons roaming on bike. And the deceased and his wife had a quarrel over the matter. Full stop. In his cross-examination, PW 10 stated that he also saw a quarrel which took place between the deceased and his wife. And he suspected, like the other village persons. Full stop. Para. PW 11 stated that he heard that the disease was killed by someone inside his house. Full stop. It was reported to him by his elder brother on the next morning, and he then went to the house of the deceased. Full stop. Going there, he found that many persons had already gathered there. Full stop. He found the accused appellant and her children weeping. Full stop. He noticed a head injury on the dead body of the deceased Full stop. Uh, This witness had deposed that prior to the occurrence command, the deceased stated to him that he had a land dispute with one Kazimuddin, comma, who was the brother-in-law of the co-accused. Full stop. He was also told that in respect of the land dispute, comma, Kazimuddin and the co-accused quarrel with the deceased. And the present accused appellant had an extramarital relationship with the co-accused. Full stop. He was also told that the disease suspected such an extramarital relationship between his wife and the co-accused. Full stop. PW 11 also stated that at the time of his testimony, comma, the accused persons, two accused persons, had visiting relation with one another. Full stop. In his cross-examination, comma, PW 11 stated that he had no knowledge as regards any case in relation to the alleged land dispute between the deceased on one side and Kazimuddin and the co-accused on the other side. He further stated that he did not know who had killed the deceased. Full stop. Para. On a meticulous examination of the testimonies of the prosecution, witnesses, the aforementioned prosecutor witnesses, that is PW 1 to PW 1, comma, PW 2, comma, PW 3, PW 5, comma, PW 6, PW 8, comma, PW 10, and PW 7. It has emerged that none of these witnesses had seen the incident of assault on the deceased. Full stop. Each one of these prosecution witnesses had deposed that they did not know how the deceased had died or who had killed the deceased. Full stop. All of them had reached the place of occurrence. Many of them had reached the place of occurrence after hearing alarm from the house of the deceased. Full stop. Well, as has been mentioned, oh, okay, we'll continue tomorrow, otherwise both have single bench. Partner, partner, finish tomorrow as partner.
May it please, my lord, in item 10, my lord, it was actually, my lord, last order reflected, it is shown as to be listed before the appropriate bench.
Okay, will be listed.
Kindly date me,
After which
well, on Tuesday, my lord, next 28, my lord, kindly.
you have already fixed the one NI.
Or any day on 29, my lord.
NI 3 appeals morning. We'll fix it,
Since it is shown as, my lord, further hearing, my lord, that's all.
It will be listed, Mr.
My lord, any date, my lord.
But Don't ask for a fixed date, we'll accommodate.
I look, I'm obliged.
I know, like you are.
May I please your lordship, item number 11, your lordship. So it has been listed for a long time, but the matter has not.
What to do?
Matter may be fixed, my lord.
No, we will not go on fixing, but there is a mandate that whoever is in detention for longer period, his appeal will be listed in preference.
My matter is matrimonial appeal, your lordship.
Matrimonial appeal, yes, fine.
My lord, actually in main case, I want to file affidavit, main writ petition,
Right.
it will every 6 time maybe can't.
The earliest the better.
My lord, my lord.
Yeah, mail to you. It will, no? It will. Okay. We keep it pending.
My lord,
I,
my lord.
He is filing the main case. Actually.
heard Mr. Didas, Nayan Senior Counsel, assisted by Mr. K. Mohammed, Nayan Counsel for the petitioners, and Mr. T. J. Mohammed, Nayan Senior Counsel. And Standing Counsel GHC. Anybody? State? No, no state. For the rest of 4 and 5.
Yes, I am 4 and 5.
Full stop. Mr. Monto has submitted that a counter affidavit on behalf of the fund number 4 and 5 will be filed within 3 weeks' time.
My lord.
Full stop. He has thus paid for listing of the case after 3 weeks. Full stop. He has further submitted that the interlocutory application
Maybe
I number so and so be kept pending.
My lord.
Full stop. As paid for, comma, list the case on after 3 weeks.
Deputy. My lord.
12/6,
Of Taiwan.
2024.
So here you will be able.
So stop. The interim order passed earlier shall continue till.
My lord. Sure. Yes.
12/6.
Deputy.
Have you got any solution regarding that?
That I have collected, I'll reflect it in the affidavit.
Okay.
Is still getting a 17A, I am still getting the original one. By this time.
11.
11, my lord, in earlier 3 occasions, my lord, it was, my lord, there is no mention about that. I'll make my sense.
Because there is another thing, because there is why.
My lord,
Because I have also been given the task to look into these rules in the administrative side. So that is why I need.
very difficult, my lord, actually, how it.
Because they have,
I have been
with
given
great
that,
respect,
I have been given the task also along with my brothers to do
At the high time. High time, my lord.
but with great respect, what I feel that lot of changes are to be made
Made,
in the
Yeah.
rules.
my lord, at-
Herculean.
Yes,
because in 1967, my lord, there is only one state. I have seen, my
But
lord, when
that-
state would come, when they earlier it was a circuit court. There is no permanent bench.
But now, under, if you, this rule 11, even then as on date, Agartala is no more a part of it, it is
Yes,
still
no,
there.
that probably very.
No, they're still there.
Still there.
So it has to be removed.
Yes.
Yeah, high time.
it
my
has
lord.
to be
Yes,
removed.
in Meghalaya also not there, my lord.
But that one solution is that is by constitutional amendment, by implication, it has to be outside. Because
No, automatically, it's
automatic-
automatic.
by
but-
implication,
By implication, but
But
it's.
by-
but not by
Not
No.
by rules.
specific manner.
Manner,
It
but by
is
implication.
By
By
implication.
Correct.
But I think that it should be removed. Then
It
it
should
becomes
be, it
more
should be.
clarity,
It-
more clarity.
When at the 2015, when this post was incorporated, there is no separate rules, no separate any order of the past, my lord.
No, not only this, there are.
Entire service rule 1967,
There-
it has
there
to
are
be, my
many
lord,
things.
recast. It has to
We
be
recast,
recast.
whole hog.
And lot of,
Because
my lord,
position in
when
nineteen sixty-seven, position is today completely different. my lord.
but when you recast the whole thing, lot of things has to be looked into in the
Yes.
outlying benches
Yes,
also.
yes.
Correct.
Not only concentrating on principal seat, lot of outlying
Yes.
benches are there. So
So,
your lordship was
Let's see,
asking, what
that's why, my
about,
lord, very carefully I'll file that.
what about the staffs? That's very important again.
But I'm not saying because of one post. It
Yes,
has-
yes, as a whole, my lord.
There are many consequences.
Why, that's why I told my learned friend, outside, we said that we have to be very careful.
Careful, because it
We
is
have,
long
it's not,
institution.
we are fighting for one of the client for
But-
that post. You have to see as a whole.
Not only us, you.
Yes,
all
yes,
the
absolutely.
people.
We are the
Yes, sir.
part of the institution, my lord, yes. That has to be.
Okay,
Yeah,
12-6. Yes, Mr. Das.
The last occasion your lordship had queried regarding that section 12 of this mines and minerals. Lordship, as per the means this rate has been fixed as per forest notification, lordship, that is orders by the governor of Assam, that is this rule, lordship, this act, forest manual, lordship. Page 53. Assam Forest Regulation 1891, lordship. Lordship can have the book.
Page,
Page,
this book.
lordship, this one, lordship.
That one.
Otherwise, lordship can take this book, lordship. No issue. I have flag marked the pages, lordship. Show some forest reputation. 1891. Oh. This rule is still there, lordship, means this act. And it has been stated in one of the judgment passed by this honorable court, lordship, honorable justice K. Surana, lordship. I am relying on this copy also. Lordship may kindly turn to page 8, paragraph 17.
This is with regard to what?
Lordship, this is in regards to limestone,
Ah.
not regarding to this, but I am just.
No, if you have read this notification,
Lordship, this is the,
this you have seen,
yes,
shown
Lordship.
it to me.
Means based on this notification, Lordship, the royalty has been fixed on sand, means art, Lordship. It can, art and clay is there. If Lordship turns to the next flag page.
Next page. Now, do you have another copy?
Lordship,
You don't have another book? এখন কিতাপ আছে নেকি? First, you have to see the preamble or whatever.
Lordship,
In exercise of the power conferred under section so and so of the Assam Forest Regulation 1891 and its amendment, the Governor of Assam is pleased to publish the following schedule of rates
Lordship,
of royalty
Lordship,
leviable
Lordship,
on all classes of forest produce
Lordship,
in Assam,
Lordship,
right?
Lordship,
So these are the rates of royalty leviable on all classes of forest products.
Lordship,
Produce.
produce.
Now let us see the definition of forest produce.
Yes. Section 3.
3(4).
Yes, 3(4).
Forest produce includes
The last one is.
A,
Yes.
the following whether found in or brought from a forest or not. Whether found in forest or brought from forest or not.
Lordship,
A,
Lordship,
there the names are there, timber, charcoal,
Yes, Lordship. It's
so and so, so and so, so and so. Right?
yes, Lordship,
B,
B.
B. The following when found in or brought from a forest. That is to say, so all these are must be brought in or found in forest.
forest, Lordship,
Now, A is, it is not necessary that it should be brought from forest or from any other place. But timber, if it is timber, charcoal, then forest produce, wherever it is found.
Lordship,
But the other part, B, these must be brought from forest.
My lord.
Lordship,
Now, there, it is not there. B is not there because we are testing the case
yes,
on the basis of that
Private
periodic
land.
patta,
but yes.
which is not forest.
Lordship, Lordship,
So forest regulation does not cover areas other than forest in respect of B.
Lordship, Lordship,
In respect of A,
Lordship.
your book,
Yes, Lordship.
Same.
Same.
And in this regard,
Lordship. Regarding the royalty, means the
Now-
amount of
now-
royalty,
royalty, ordinary it is mentioned because that on that day,
the-
discussion was made as regards Assam Minor Mineral
Minerals
Concession Rules.
Lordship,
We found ordinary art,
Lordship,
but royalty was not there. Royalty rate
rate
was not there.
in this.
Now, there
rate
is a notification with amendment to the Assam Minor Mineral Concession
Concession
Rules.
rules.
Have you got the
No,
copy?
that I have.
that I have taken, but that there no rate is being fixed.
No,
but
now it is fixed.
Now new one.
Now,
Now see amendment to Rule 27.
Rule 8. Rule 27.
Now there is a rate.
Lordship,
What is the rate?
Rate is 9%. Now.
9%. Now come to sub-rule Roman 5. Amended. The rates as appended in the third schedule and process as prescribed above shall be applicable to,
Fresh tenders. Fresh tenders. Lordship.
what do you say?
My submission is,
And otherwise, this is the duty of for every tender process.
Lordship, this is.
Wherever any government department undertakes a contract work,
Lordship,
then since it is because what Muslim Ali says, if it is by law or by any specific condition in the contract. Apparently, in these cases, there is no specific condition in the contract agreement. On the other part, you'll be getting opportunity so that
yes,
the issue is crystallized.
yes.
On the other part, if there is a sanction of law,
Lordship,
now you have referred to forest produce and then notification.
Lordship,
So the whole notification is based on forest produce.
forest produce.
And definition of forest produce is there
Yes, Lordship,
in the main act.
Lordship,
There no mention of any ordinary art
Lordship,
in the definition.
Lordship,
And A and B classified.
Lordship,
If charcoal is found anywhere, it is forest produce. Whether it is brought from any forest or from a patta land,
Lordship,
it is forest produce. But so far as ordinary art is concerned,
Lordship,
that is not there.
not there. Only the table is there. Only in the table it has been mentioned.
Table is mentioned, but and that thing is based on forest produce.
Forest produce. Yes, Lordship.
If you bring something from forest, maybe it is within the jurisdiction of forest department.
Lordship,
But if it is periodic patta land, whether forest department exercises jurisdiction,
Lordship. That is,
and this has made clear now by law, government agencies now can deduct royalty at the rate mentioned therein
Lordship,
from fresh tenders.
fresh tenders. Lordship, that is, your Lordship is right. Lordship.
So what do you say about this? This is the issue, those have facts
Facts,
that have emerged.
Lordship,
Anything?
there is, Lordship, regarding the act, which 1891 act, it is still there, Lordship, because in the judgment, means in the order, paragraph
So
70.
first we have to see the issue.
Yes, Lordship, regarding
Then
that
you
also.
cannot pick up
Yes, Lordship.
one paragraph from judgment,
Lordship.
another paragraph from another judgment,
Lordship.
combine together and mix it.
No, that will be
Let us see.
mixer. Paragraph 17, Lordship.
No, paragraph 2.
Correct. Of the.
Your judgment,
Yeah, yes, that is a limestone carrying,
stone crusher.
stone crusher. I just like to point out, your Lordship, that it is still there, means 1891 act is still there.
I'm not saying it is not there.
Okay. Yes.
I'm not saying it is not there.
Lordship,
Question is, what is forest produce?
Lordship,
As per forest regulation.
Lordship.
Forest regulation does not say that ordinary art picked up from periodic patta land is forest produce.
Lordship.
If you bring it from Povitora, yes, you are bringing in from forest. You must have to pay
Lordship,
to the forest department.
Lordship.
But here he picked up. And there is a procedure in Rule 27. To the owner, an application is to be made.
Lordship.
He made to the forest department.
Lordship.
That is what we discussed.
Lordship.
And at that point of time, forest department has to accord permission.
Lordship.
Suppose it did not accord permission. What will be the consequence? Anything, Mr. Hazarika, from here? suppose you have applied rightly
My lord,
for permission
my lord,
with the consent of the landowner,
my lord,
right? To extract ordinary art.
my lord,
You have shown me some application.
my lord.
Range officer forwarded it to the DFO.
Yes, my lord.
Now, forest official was sitting over the matter,
Lordship.
right? But in any view of the matter, at that point of time, no rate of royalty was there.
My lord. Yes,
Now, suppose he has collected the art
Lordship.
from periodic patta land
Lordship. Lordship.
as per the permission he sought in his application. Without permission, he started collecting.
Gotcha.
It might be an offense,
Yes. Yes.
even if it is an offense. But whether that permits, he may be criminally prosecuted. But whether that permits collection of royalty when royalty is zero,
Lordship, there is payment of royalty is there because other contractors means only a
that
portion.
is, I am not saying, other contractor, I don't know whether they have agreed or not.
No.
We are here when
Lordship.
the issue is before this court.
Yes, yes, Lordship.
Let us see any
Lordship.
consequence was there.
my lord, 27/5, the application made.
Application for grant of farming service submitted in so and so application service submitted along with following documents. Where proposes to active layout plan or where art is to be removed, written consent of landowner, copy of the partnership deed. A permit for excavation or ordinary art shall be granted in form PIM4. Where is
Yes.
PIM4?
PM4, my lord, my book is 849.
Page. PIM4. PIM4.
In my book, it is 849,
PIM.
compiled.
You have book or what?
That compilation,
Any internal page? No.
no, it could be good.
PIM4. MSC, MP. PIM4.
Question. There is to be. Some guidelines are written. How to extract.
And where is the rate of royalty?
Rate of royalty is schedule 1, in the schedule A, sorry, first schedule,
Okay.
in the earlier book, first schedule. Rate of royalty, schedules 8.6, 26.6, and 27.4.
Madras. This GH Bijapura is in respect of Constitution Rules 1994.
Lordship.
My lord.
It has also been mentioned in one of the recent judgment, that is division bench passed by this division, our High Court, Lordship. This is decided on 16/10/23. GH Bijapur, this is regarding the work order issued by the NF Railway, Lordship, on artwork total send, that is in paragraph 3, Lordship.
Mark.
Clauses. Clause 20. Makes a thing very complicated.
Bidapura Lordship will find there is a specific location was defined from where the land to be collected. Then that the petitioner in that case, he obtained land from separate plot of land. And there is a specific clause in the condition of contract, there's a royalty.
I had to find out the actual ratio of this, needs many reading. Otherwise, let us concentrate on the facts.
And thirdly, my lord,
Post it some other day, let us concentrate on the facts first.
my lord,
First the facts,
Lordship,
then law.
my lord.
may I request your lordship, lordship may otherwise take the assistance of the Learned Standing Council, P.N. Goswami, he is the additional advocate
If
general.
I feel,
Forest,
if I feel,
lordship, that is
if I
what
don't feel, will
Lordship,
not,
lordship,
let us
up to your
be
lordship.
clear about the facts
Lordship,
in these cases.
lordship,
We'll just first, because needs many readings.
lordship.
And then this Assam Minor Mineral Conservation Rules 2021,
Lordship.
is it notified? Gazette? Any idea?
No,
That's my lord, only
Okay.
that
No.
later, my lord, the second page. It is
No,
Notified.
Gazette.
It is not been notified, lordship.
How can you say?
If it is not notified,
Gazette.
no, it must have communication from us.
Uploading in a website. I tell you power.
No, notification is to follow this. The page 2, second page.
7,
The communication is there.
2021, 1 minute.
That communication is there.
1 minute. 7, 10, 2021. This has been referred in this,
Minor mineral concession.
no, this particular judgments.
Rule 46, 48 and 31,
Where is that 1/9/2009
lordship.
notification? Any idea? 1/9/2009.
That.
Many things are discussed there on that notification. The petition of High Court. এখন থেকে আমার আসলে সাবমিশন We'll note the facts. We'll take care of the law later on,
Lordship.
right? Which one is first?
The
6391.
639.
Lordship. One more submission is there. Or lordship. Lordship is going to pass the judgment.
No, I'll note down the facts.
Lordship.
There are so many judgments, appears to be conflicting to one another.
Lordship.
It needs a patient reading
Lordship.
and patient hearing.
Lordship.
But so far as the facts are concerned, whatever is stated in the petition,
Yes.
let me take care of that.
Lordship may take 6421.
Why?
No, both are identical. It is above the list. Therefore,
No.
There are
If the facts are similarly pleaded, we take care of both the
Yes.
petitions, but in the number. Negaliko. include the repetition, comma, WBC number 69/1/2021. Executing paragraph wise लिखी जाओ. The petitioner, the writ petitioner is A, class 1A, within class dash 1 within bracket A, contractor registered with the Water Resources Department, comma, Government of Assam. First, he participated, the petitioner participated in a competitive bidding process initiated by a notice inviting tender dated 13/2/2014, issued by the respondent number 4, comma, that is, comma, the executive engineer, North Lakhimpur Water Resources Division, comma, Lakhimpur, Assam, for a package, for a package,
Yes, ma'am. Package.
okay, for a package,
There are different for the.
for a package under for a package, for a group of work,
Yes, Lordship.
for a group of work,
Lordship.
which was part of a contract work, colon dash, page 22 থাকিব, quote, that management of River Dikrom along with river training works on both banks embankment in the Lakhimpur district within bracket Assam. Unquote. Page 22. ঠিক আছে? After completion of after evaluation of the bids, comma, the writ petitioner was awarded a contract work, comma, described in Annexer dash Roman 1, comma, of and work order dated 24/12/2014, right?
Right.
Comma, pursuant to a preliminary work order dated 11/12/2014. This is formal work order.
Yes.
Of a formal work order pursuant to a preliminary rule. By the formal work order, comma, the repetitioner was informed that as he had signed formal tender after depositing security deposit, comma, he was finally selected for acceptance at the rates noted in Annexure 1. Full stop. The repetition was thereby asked to start the work and to show proportionate progress. Full stop. As per Annexure 1 to the formal work order, Annexure 1 to the formal work order read as under page 42. Huh? Listen. Huh? Also para. It is the case of the petitioner that he had successfully executed the contract work awarded to him by the formal work order dated so and so. Huh? Full stop. The petitioner has stated that first bill in respect of the said contract work was released in the month of March, 2015. And the said bill amounted to rupees 2 crore 22 lakh 71,525. Full stop. Thereafter, para 7 of us, huh? Para 7. As part payment of the second running bill, perhaps,
Running bill.
comma, an amount of rupees 2 crore 11 lakh 86,511 was processed and passed by the respondent authorities on 6/6/2019 by deducting relevant taxes including income tax, SGST, CGST, cess, SD, etc. Full stop. In the said bill, the respondent authorities in the Water Resources Department. Where is the bill?
Lordship will find page 82.
Page
82.
on. In the said bill, while processing and disbursing the amount of rupees 2. All right. The respondent authorities in the Water Resources Department had also deducted an amount of rupees 29 lakh 40,000 259 towards forest royalty and a further amount of rupees 73,506 towards income tax on forest royalty. Full stop. As a result of the said two amounts, reduction of the said two amounts towards forest royalty and income tax on forest royalty, comma, an amount of rupees 1,71,13,439 was disbursed to the petitioner as part payment of the second running bill. Also, the petitioner has further stated that after such payment, comma, an amount of rupees 2,05,49,574 was pending as outstanding to
My
be
lord,
paid
at
the time of
Filing.
preparing the writ
My
petition.
thereafter,
That is
yes,
full stop. The petitioner has further stated that as on 27/4/2020, the respondent authorities in the Water Resources Department, while processing to make payment of a bill amounting to payment of a bill. We're contemplating to deduct 10% from the final bill amount of rupees 2 crore 5 lakh 40, right?
49,570.
574. That is a case.
Yes. Thereafter, they have paid some bill and deducted also. Therefore, we have come
Next
up with
case.
contempt petition.
Read petition. 6421. Huh? Competitive breeding process. Same, Nikki. NIT is same?
No, NIT is
And
different.
it is different, river is also different.
Huh?
River,
It is
River
in
is
respect to Ranganadi River.
Ranganandi River.
Page
Page 23.
23 চাই লওঁ প্ৰথমটো কৰি ল'বতো প্ৰথমটো কৰি লৈ ইয়াতে লিখিব A class 1A contractor ইয়াতে লিখিব সাবজেক্টটো যেটা ফ্লাড মেনেজমেন্ট কৈছিলো ন সাবজেক্টটো লিখিব ফ্লাড মেনেজমেন্ট পেজ 21 ত আছে or page 21 আছে pencil dark মাৰি দিছো flood management of river Ranganodi along with training work on both banks embankment in Lakhimpur district Assam unquote right লিখিব formal work order dated 24/12/2014 আৰু preliminary work order number দিলে ডেট নালাগে আৰু 26 বাকিখিনি একে থাকিব।
The amount will be different. I think.
Amount
Page 25, schedule. Annexer ঠিকে থাকিব, schedule. Page 25 আছে। Huh? তাৰ পিছত সেইটো paragraph 7 আছিল, চাব লাগিব।
Paragraph 8, my lord, page 10, the
Oh.
payment. The tender amount is also different.
Tender amount is already in the annexer schedule
Yes,
1.
yes, lordship.
We are not repeating anything. I have told to reproduce this in its entirety. First, you will keep the botheration. First bill running bill, huh? 80,000,
80 crores, 80
seven,
lakhs.
80 lakhs 75,000. In the year 2015. তাৰপিছত লিখিব second running bill যে a part of this, SGST এইবোৰ সব একে আছে। Forest royalty 15,07,775.
Yes, sir.
Income tax on forest royalty 37,694. আৰু bill amount আছিল 1,05,15,175.
170.
Second running bill, huh?
After
After deduction of the said two sums towards forest royalty and income tax on forest royalty, comma, an amount of rupees 79,72,949 was disbursed to the petitioner towards payment of the part of the second running.
My lord.
Pending on the date of preferring the writ petition, amount to 1,06,65,250.
250. Yes.
আৰু contemplate যে কৈছিলো for the final bill 1,06,65,250. Para. In view of deductions of the aforementioned amounts from the running bills of the two petitioners, comma, the two petitioners have approached this court by filing these two writ petitions. Seeking inter alia direction to the respondent authorities in the Water Resources Department to pay their bills for execution of the contract works, awarded by the formal work orders mentioned above, without deduction of any sum towards forest royalty and income tax on forest royalty, and to release the final bill amount against the contract works without any deduction towards forest royalty and income tax on forest royalty, on the premise that such deduction of forest royalty towards forest royalty and income tax on forest royalty is unauthorized in law. Full stop. Para. The respondent authorities in the Water Resources Department have contested the have contested by controverting the contentions of the writ petitioners by filing counter affidavits in both the writ petitions. Full stop. Para. I have heard Mr. P. Hajorika, learned counsel for the petitioners in both the writ petitions, and Mr. R. M. Das, learned standing counsel, Water Resources Department for all the respondents. Full stop. Learned counsel, as the learned counsel for the parties, as the issue involved in both the writ petitions, as the controversy involved in both the writ petitions is common, comma, semicolon. Exchange of pleadings is complete. And as requested by the learned counsel for the parties, comma, both the writ petitions are taken up for final consideration at the admission stage. We'll go through it step by step. Not
The
possible.
prayer millet, I have also paid for refund the amount they have already deducted.
If you are unauthorized,
Yes, ma'am.
then that is the consequential,
Yes.
will be the consequential direction.
My lord.
If we find that this deduction is unauthorized, the natural consequence
Yes.
is to be the refund.
Yes.
We'll go through it. It is very difficult. Everybody says different things.
In Bijapura
May I-
millet, I have also found one thing, my lord.
Since
Even that it says the department is not authorized to do so. And they directed the competent authority, that is the forest department, to issue notice. And affording some opportunity thereafter to deduct. And
No, in RCN construction also,
My
I
lord.
have seen RCN construction, single judge. Discuss with Muslim, Ali, Bijapura, and all others.
yes,
And he draw up a conclusion
my lord,
that has been challenged in division bench.
my lord.
That is a judgment. এই যে judgment কি আমার life এ একটা কাজ করে দিব। সময় করে করে দিব। এইটো next Tuesday, 3 p.m.
next.
I'll be sitting in a division bench. Otherwise difficult.
No.
Yes,
Mr. P. Hajorika for the petitioners. These are, I have just dictated,
my lord.
so that not required. And I am thus standing also, Water Resources Department. Also, as sought for Metropolitan Council for the parties, raise the cases on date 28/5/2024 at 3 p.m.
Lordship.
My lord.
Interim order.
Lordship.
I'll be sitting in a division bench.
Lordship.
I'll not like to disturb the division bench.
No, my lord, that is correct, my lord.
Yes.
28, I have a commission.
3 p.m.
They will come from Delhi.
Huh?
The cross examination of doctor coming from Delhi.
Oh, what date you need?
Any other date at your convenience. Lordship.
30. 30.
Lordship.
Oblige.
Okay.
By 20.